The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. Is it deliberate to have our lights off like that?
Seems. I thought that was just me.
I don't know if you need to be in the light, but you may want to experience normalcy. All right, we'll call the first case, Amos versus Amazon Logistics, and Mr. Rigsby, we'll hear from you.
If it may please the court, my name is Jesse Rigsby. I'm here with my colleague Danielle Wilson. We represent the plaintiff's appellants in this appeal. The court is presented with two distinct main issues. We only have to win one to prevail. The first main issue is this: is the arbitration clause excluded from enforcement under the Federal Arbitration Act and the Washington Uniform Arbitration Act because Ms. Amos was, with respect to the FAA, a transportation worker engaged in interstate commerce, and with respect to the WUAA, Amazon's employee. The second issue is the arbitration clause in the program agreement in which it's embedded an illusory contract under Washington state law such that the arbitration clause was never formed as a contract? I will concentrate my remarks.
Well, that one you can leave behind. That is law school contract law. Seems to me if two promises facing each other are consideration. And in this case, the idea that if you want to consider continuing as a thing, you have to accept the change. And you can argue it if you want, but I'm speaking for myself now, but I think you might as well stick with the other ones.
Okay, well, I appreciate your remarks. Obviously, in the briefing, we make our point about why that may be not the case, but I will respect the court.
Well, you know, she didn't have to continue on the contract. It said we're modifying, and if you don't like it, you don't continue. If you continue, you agree to it. And that agreement, implied agreement, she had the choice, is the consideration. A promise for a promise is the way contracts are formed.
And again, I'm not going to spend time on it if the court doesn't find it useful. I will just say that the exit costs and and it wasn't.
Well, whether it's exit costs, it's a question of whether there's consideration, not whether it's costly.
Well,
whether there's a promise for a promise.
Again, if the court finds that that's a lost cause, then I won't.
Well, I can't go so far as saying it's a lost cause, but I think you do better by focusing on the other issues.
Well, I will take the court's remarks to heart.
And also, I don't speak for the court.
I understand, but I was going to concentrate on the first main issue.
Yeah, okay.
Anyway, as a starting point, there's one overarching question that permeates all the others, and it's this: what is the relationship of the parties? Is this, as Amazon urges, a true arm's-length business-to-business commercial relationship, or is this, as plaintiffs urge, an employee-employer relationship?
May I ask you a question about that? A big part of your brief, as I understand it, argues that Ms. Amos is an employee and not an independent contractor under the standard we use under the FLSA, the control standard. And I'm trying to figure out, is that relevant at all to the FAA question, or is that only relevant to your Washington state law question?
Well, and thank you for the question, Your Honor. We think that it's relevant to the FAA question in the sense of it gives context and some ability to contextualize what's going on with the creation of a business entity and the interposition of a business.
But I guess in New Prime, right, the Supreme Court made clear, like, we don't care if it's an independent contractor or an employee. We're past those formalities. We just look at kind of the substance. So I don't understand why, after New Prime at least, there's so much emphasis on whether Ms. Amos would qualify as an independent contractor or an employee.
Well, and it may be we're swatting a fly with a sledgehammer, honestly, that we think by showing that she's an employee that we very easily make the New Prime showing at that point. And whether it's done under the FLSA.
Well, you say it's easy, but didn't New Prime just really involve a situation where the parties agreed that the individual owning the truck was the LLC. In this case, we have an LLC that had 450 employees, and the arrangement was between the LLC and Amazon. So it seems to me to say it doesn't make a difference. You may be able to read through a LLC to a person if it's an individual. But here we have a case where she is a formidable company. She had a lot of drivers.
And with respect to, let me start out with respect to the 450.
And you had a lot of trucks? Yeah. What, 450 trucks? Or what, is that right? The 450 drivers, you had a couple hundred trucks.
I don't know.
And you had a 6-acre tract of land covered with a warehouse or something.
Well, I don't.
Up there delivering all over Durham County and elsewhere. This is a big business.
Well, let me.
I was really interested in this because I've seen those trucks running around, and sometimes they even deliver to us. But I wondered how they did it all, and so I was interested in the background of it. It's amazing. But your lady, your client, who trying to interpose her rights under this contract with the Amazon has with the LLC, is the owner, right? And a lawyer there.
Yes, but let me.
Very successful business.
Well, I wouldn't say that necessarily. But let me address at least the 450 trucks, or 450 employees. We say 450 employees, but what we don't say is that that was under the term of the entire 2-year period in which she was operating.
You know, you didn't tell us it was 450. Amazon told us it was 450. You didn't even tell us that there was more than one.
With respect, Your Honor, we actually do say 450 employees in the complaint, and that's verified.
I'm talking about reading your brief.
Okay. Yes, she had employees, but she was hiring those employees for Amazon, and she didn't control the hiring and the managing, the supervising, the firing of those employees. And so basically what Amazon was doing was using Ms. Amos and the LLC that it caused her to create and made her create as a pass-through. And so that context is important to understanding this relationship. And going back to and as far as the number of trucks, I don't believe that's in the record. Amazon even controlled the number of trucks. She would get surprise deliveries of trucks. She wasn't controlling that, Your Honor. With respect to New Prime versus Oliviera, that's a good case for it.
It's not in the record. I just asked you how many trucks you had.
I honestly don't know the answer.
Well, I'm surprised you don't know the answer.
Well,
You had 450 drivers.
I mean, as far as the number of trucks, it varied over time. What is in the record is that Ms. Amos did not get to control the number of trucks that she would have. That it was Amazon that was controlling that, just like Amazon was controlling.
Amazon wanted these packages delivered all
Yes.
the time.
Yes, Your Honor.
And that's what the company here, your client, was obliged to do.
Yes, Your Honor, as part of a DSP program where Amazon was setting this up all across the United States. As a system we urge to violate the FLSA. And so then New Prime versus Oliviera is actually a good case for us because there you see the same sort of structuring, the same sort of interposition of a business entity between the defendant company and the individual. And what we're urging in this case is that Ms. Amos is the one who's protected by the FAA's transportation worker exclusion. Ms. Amos is the individual who is protected.
You're saying she's a transportation worker under the statute. Is that's the basis of your claim?
Yes, Your Honor.
They would disregard the business situation.
Well,
Disregard the fact that there are 450 employees and several hundred trucks and 6-acre operation and thousands of packages have been delivered every day, and she owns it.
well, let's not disregard.
She's a big business. She operates a big business in the Durham area, a major business.
Well, keep in mind that there were other DSPs operating out of in the Durham area. She wasn't the Durham operation. She was one of many, one of several. And with regard to with regard to Ms. Amos, she's the individual that is protected by those. We've brought the LLC into the case because of the rules of pleading allow us to bring a case with both plaintiffs. We could have not done that. Or we could have brought two separate cases. Rule 1 of the Rules of Civil Procedure says that that's a silly thing to do, that the formalities of doing that are unnecessary. To the extent that the LLC is a problem in this case, there's a solution. Besides any sort of equitable solutions or any saying that, well, if Ms. Amos isn't bound, then she couldn't bind the company. The other solution is under Rule 21, the LLC can be severed sua sponte from the case. It can be dropped as a party from the case.
Well, but whether the LLC is in the case or not, right, you have to show it's not just, you have to show that the contract is a contract of employment, right? And the contract, as I understand it, is between the LLC and Amazon, and it just looks in substance like it's a commercial contract between two commercial entities. So I'm not sure it really matters who the parties to the case are. I mean, you still have to work with this contract.
Yes, of course, but then you're looking also, should be looking, if not at the FLSA, at the common law of who's an employee. And you're looking at the agreement that we believe that we've made a showing through actual facts in the record that Ms. Amos was the employee of
And so your position is that this contract, which says sort of how much, what it is that the LLC has to do for Amazon in exchange for what it will get from Amazon, is actually an employment contract between Amazon and Ms. Amos.
Yes, Your Honor.
Does it say anything about like how much, what are the parts of the contract that make it seem like an employment contract to you?
Yes, Your Honor. First, it calls Amos you. She's the one who's binding her company.
Does it say stuff like, you know, here's how many vacation days you'll get? Like the kinds of things you usually see in an employment contract?
No, but then it incorporates the program policies, and those program policies control every single aspect of what she's doing. And additionally, the amount of control that Amazon actually portrayed, or actually had over Amos, that has to be looked at from the standpoint of the common law. Otherwise, if we simply just look at the four corners of it, it's misleading. There's a case, it's a district court case, but it deals with similar facts. It's Canales versus LePage Bakeries out of, I believe, the District of Massachusetts. And in that case, you had a similar example of a distributor agreement entered into between a defendant company and a business entity that was interposed. And yet, that did not prevent the owner-operators from saying that that distributor agreement is a contract of employment for purposes of new prime. The distributor agreement didn't prevent them from performing services, and in fact, even Amazon intended that the individual be directly tied to it. There's in the record there is talk about the change to the business, to the ownership, where there couldn't be additional owners, and that was to, in Amazon's words, to paraphrase, to keep the individual as being involved in the business. Amazon intended the individual to be the one doing the work. That's very clear from the design, and to the extent that the court only looks at the four corners, it's getting a misleading picture. Thank you.
Thank you. Bro?
May it please the court. Diana Bro for Appellee Amazon Logistics. Plaintiffs asked this court to be the first to find that a business entity can avoid a contractual commitment to arbitrate under statutory exceptions limited to individual human workers. Two issues on this appeal. Is there a valid agreement to arbitrate? And whether that agreement to arbitrate in the contract that Kirk Amos Delivery and Courier LLC executed with Amazon to provide delivery services to Amazon through its personnel, whether that arbitration commitment can be avoided under both the FAA and the Washington Uniform Arbitration Act.
Well, I gather if it is arbitrable under the FAA or is subject to the FAA, that ends the matter because the Washington statute could not withdraw arbitration once the FAA granted it. And so it seems to me the focus should be on the federal statute. If the federal statute doesn't apply, then we would still have to address the Washington state statute.
Correct, and both statutes here provide for.
You don't have to talk about the state of Washington point. I think I agree with Judge Niemeyer. I don't understand what that got to do with this.
Well, state law provides an independent basis for enforcing.
Why we need an independent basis if the FAA applies.
So, exactly. And so I would like to focus my argument on the FAA. So Section 1 of the Federal Arbitration Act contains a narrow exemption. The inquiry under Section 1 begins and ends with the contract. The statute directs that the Section 1 exemption applies to contracts of employment of seamen, railroad employees, or any other class of workers engaged in foreign or interstate commerce. There are two important aspects of this exemption. One, it applies to contracts of employment as a threshold issue. Second, of certain types of transportation workers. In Circuit City, the Supreme Court instructed that the statutory exemption is to be construed narrowly, and that the residual clause, the any other class of workers, must be construed consistent with the examples, the named examples that precede it: seamen and railroad employees. Both of the named types of transportation workers are natural persons. That is, in fact, the through line from the statutory text to the Supreme Court precedent, is that this exemption is directed to contracts of employment. And in New Prime, the court grappled with what is a contract of employment? And the Supreme Court looked at contemporaneous definitions of employment. Footnote 1 of the opinion provides those definitions, and they're directed to the services of an individual human worker.
Is your position, and I took it to be this way from your brief, is what you're saying that an incorporated entity can never have an employment of contract?
I think for purposes of the Section 1 exemption, that bright line rule, and it's been adopted by lower courts below, I think particularly instructive is the Western District of Pennsylvania decision.
But then in New Prime, that was a corporation. And I understand that nobody was arguing that in front of the Supreme Court, but it would be kind of a huge mistake for the Supreme Court to have made. I thought the whole point of New Prime was we don't get hung up on the formalities. We look at the substance of the agreement.
So in New Prime, the parties agreed that Mr. Oliveira was an individual worker,
Right.
and that the agreement at issue was directed to.
Right, and if all of that is true, but I understand your position to be that even if all of that is true, look, if the entity is incorporated, it's not an employment contract for purposes of this exemption.
So this was actually the subject of oral arguments.
If you could just, is that your position? That even if the facts are as they were in New Prime, as long as you are incorporated, you do not have a contract of employment for purposes of this exemption?
Yes, Amazon's position is that that bright line rule is consistent with the statutory text. The Supreme Court's Congress and the Supreme Court have said that this is a narrow exception that applies to individual workers. In Circuit City, the Supreme Court also observed that arbitration is not a bad outcome. There's nothing per se wrong with arbitration, and in construing a narrow exemption, a bright line rule that would avoid many trials and protracted litigation over whether the exemption applies. So we think that the bright line rule makes sense. So just a couple of important facts here. It's undisputed that.
I guess, I'm sorry, I do have a follow-up question. Just assuming hypothetically, I didn't agree with that, do you have a fallback argument?
I think the fallback argument is actually contemplated by the RNC Oilfield case, where the court, and actually at oral argument in New Prime, there was some very instructive colloquy on this very issue. And Mr. Oliveira's counsel argued that in most cases, you stop at the identity of the business entity. Like, you're gonna know whether this is a business or an individual, whether this is a business contract or a contract of employment. In the ordinary case, is not going to be a complicated inquiry. And that is why a bright line works. What RNC Oilfield says is, if there's a question of fact, or if there's a disputed issue about whether this contract that is in form, or a business contract.
Yeah, like
but
in New Prime.
Effect,
Like in New Prime.
yes,
Yeah.
if in fact this contract is directed to a company engaging the services of an individual human worker, then that contract might be both a business contract and a contract of employment, depending on the terms.
Yeah, like what the Supreme Court said in New Prime.
Pardon?
Like what the Supreme Court said in New Prime.
Well, what the Supreme Court held in New Prime as contract of employment is defined by reference to contemporaneous sources and directed to the engagement of an individual person's services. So I think there's also some helpful guidance from the Fifth Circuit and the Supreme Court on the narrowness of this exemption.
Why are you spending so much effort on that? It seems to me, I thought your argument basically was set aside New Prime, because in the First Circuit, the parties agreed that he was a worker, that the LLC was they read through it because he owned the rig, and there was nobody else, no other employees, anything else. But in this case, we have a business entity that is capitalized, that hired 450 employees, that had trucks, provided delivery services, as opposed to being a worker. And it's a business contract, and it seems to me that's your argument, isn't it?
That is most certainly our argument on these facts.
I mean, categorically, the question might be, can a corporation, an incorporated corporation, ever be an employee? I've heard of incorporations being agents of other corporations. Whether they can be employees might be a dicey question. I don't think that was answered in Prime. There was an LLC, which is a business entity that gives limited liability, but that was never, the facts there didn't present a heavy issue. I mean, he was an individual, and he was the only individual. He was the worker. And the First Circuit agreed on that, and the Supreme Court didn't challenge that or didn't take that up. But in this case, if it was that same situation, I think we would have some difficulty, wouldn't we? If Ms. Amos was the only delivery person, and she formed an LLC and did the deliveries herself under all kinds of control, she might be able to argue, I'm a worker.
Well, certainly that would be a very different case than we have here. In this particular case, the contract between Kirk Amos Delivery and Courier Services LLC and Amazon had no specific provisions directed to personal services by Ms. Amos. She herself, in describing what she did for her company, describes that she did HR functions, administration, hired and supervised employees. Those functions under this contract could have been performed by any of her 450 employees. So starting first with the contract, there's no term in this contract that can be construed as a contract of employment of Ms. Amos. And then, of course, we have the facts of this case, which are that, in fact, the company had 450 of its own employees, and there's certainly no implication here that the company wasn't a real company. In fact, plaintiffs have put into the record that Ms. Amos apparently received an offer of $1 million to sell this company. So I think that in the hypothetical, a single worker is so far removed from the facts here, and I do think but that would be an extraordinary exception to the norm and no reason to deviate from a bright line rule.
Is this LLC in your a term under North Carolina law or Washington law?
I don't know the answer to that question. The agreement,
Amazon required her to form a corporation. And she formed this, whatever it's called here, Kirk Amos Delivery and Courier LLC. Was that formed under North Carolina law or Washington law? What's LLC mean under one of those laws? What's the LLC mean then?
it's under North Carolina law.
What's the LLC mean?
Well, it's a limited liability company.
That's what I thought.
And
But it's treated the same under North Carolina law as any other business corporation,
and on these
for the most part, I think.
facts, I don't think that it can be reasonably disputed.
No, it's not disputed. I just want to find out.
And I was just going
I'm trying to find out the facts still. I'm still trying to find out how many trucks they got.
Well, I certainly wish I could answer your curiosity on that point.
No, it's not curiosity. I'm interested in it. You're saying that's the reason she can't be an employee is that this is an LLC. It's a big business down there.
Yes,
All right.
that's relevant to the section.
I understand that, and that makes all the sense in the world, as Judge Niemeyer has talked about. It's distinguishable from that case that you were talking about.
And
On that point, but they say that, well, she's a transportation worker. She drives the trucks herself. She's simply a delivery person. Well, they didn't tell us that there were 200 or 450 delivery persons that she had working for them. She actually says they're not working for her. They're working for Amazon directly. That's not what the contract says. But anyway.
And I guess just to sort of follow up on this, I do understand why your client, Amazon, would benefit from a bright line rule that any contract between two corporate entities, an LLC, any other form of corporation, and Amazon is per se excluded. It cannot be a contract of employment for purposes of this exemption. But would you agree that we do not have to adopt that rule to decide this case?
Absolutely not.
I'm sorry, you do not agree. You think we have to adopt that rule to decide this case? Sorry, I asked you like a triple negative question.
Sorry, I was not following them all.
Yeah.
It might still be on Pacific time. So in this case, this is not a close case. This case can be decided by
I suggest you say I agree with you.
I agree with you.
Okay.
I will accept that invitation. To the point of this being a company, I don't think that it can be reasonably disputed that plaintiffs had no benefits from the corporate form. A company that has 450 employees and has leased fleets clearly benefits from the protections afforded business entities.
Who owned the trucks?
In this particular case, I'm not sure if the facts are on the record, but the trucks were leased.
Leased from who?
They were leased from third-party companies.
What was the third-party company owned by Amazon?
No.
Okay.
I mean, that's not,
But it was leased by the plaintiff here, Kirk Amos Delivery and Courier.
yes.
They're the,
And it's in the record, and plaintiffs admit,
I understand.
Ms. Amos admits, that part of the functions that she executed as the business owner were directed towards leasing and managing the fleet.
but we don't know how many trucks there were. That's not in the record.
I have not discovered that fact within the past 2 minutes. Although I think seldom.
Well, you got 450 people driving them, though.
Indeed, that we agree on.
They drive them 24 hours a day. So you need 3 shifts, maybe.
So I want to touch briefly on a point. There was questioning of plaintiffs on the relevance of the FLSA. And I just think it's important to note that that statute has no relevance to the Section 1 inquiry. And I think plaintiffs' argument about its application here highlights just why the test is not applied to businesses. And plaintiff's theory of the case is that Amazon exercised sufficient control over the business and its owner to make a company and its owner employees. And again, the relevant inquiry with respect to Section 1 is directed to the contract and whether or not a company meets the economic realities test of control is not relevant to the Section 1 inquiry, and frankly, rather nonsensical. Businesses aren't entitled to the statutory protections of the remedial FLSA, which is directed toward fair wages.
Well,
for
to be
workers.
fair, I think the argument, according to the plaintiff, is parallel because Amos is arguing that she's exempt from the FAA because she's an employee or a worker, and this is a worker's contract. And she claims that she's entitled to FSLA remedy because she's an employee. So in the sense that there's some parallelism there. But obviously, we have to focus on the language of the FAA and determine whether this is an employment contract or delivery services, commercial delivery services contract.
So
Is that it?
in sum, because the FAA enforces a valid agreement to arbitrate that binds the parties here, the court should affirm the district court. Thank you for your time.
All right, thank you, Ms. Bro. Mr. Rigsby?
Yes, and if I may, I believe the starting point is I need to clarify some of the factual issues that have been raised. The first issue is the number of trucks. While it's not in the record, I'm informed that she actually owned 2 trucks during the entire time. Again, not in the record, but just for your information.
How many did she lease?
I actually don't know the answer to that because it changed over time.
She needed to provide her employees with trucks, right?
Yes, of course.
All
And
right. So it's sort of whether you lease an automobile or you buy it isn't the issue. It's the question how many they had. And she was supervising 450 employees and trucks and land and warehouse and distribution center and all the employee relations and benefits. That was all part of her business.
And with respect, I believe that's an inaccurate statement.
That's an inaccurate?
Inaccurate statement.
Well, they weren't delivering to everybody around Durham?
Yeah, yes, of course.
They were, weren't they, for Amazon?
Yes, but as
And
far
we
as-
see them out there on the highway. We drive highways, and we live in homes, some of us, and they drive up and deliver things. And it said they have 450 employees, and we'd see these Amazon trucks. They said Amazon on the side of them, or Prime or something. And you got 450 employees, and nobody knows how many trucks they got, how many trucks they need. We know that Durham itself has a population of nearly 300,000 people. That's a big area, and they delivered for outside Durham, right?
So let me.
Beyond Durham.
As far as the number of employees, again,
I don't know why you all are contesting or trying to conceal the facts from us.
we're not trying to conceal
Well,
the facts,
then-
Your Honor. We're trying to clarify the facts.
Give us a straight answer.
Okay.
You said they own 2 trucks.
Yeah.
She says they lease the trucks.
And they-
Well, how many trucks they lease? 250?
No, Your Honor, I don't believe that. So
Okay.
as far as the leasing, that was through a company that Amazon put forward, and they had to lease it through that company, according to the record.
Well, that's fine. That's all right. That's what I ask about. How many trucks are they using? Nobody knows. As if we're not supposed to know what the facts are in this case.
No,
And you can think, well, they're not relevant. Well, they must have been relevant because I asked about it. And I'm sitting up here as your judge.
Yes, Your Honor.
Relevant to me.
Well, unfortunately, that fact is not in the record, and
All right.
well, as far as, if I may argue, as far as the 450 employees, again, we're on a.
Is that in the record?
Yes,
You said it's in your complaint.
it is.
All right. 450 truck drivers, or for the most part, they're truck drivers. And if you got 450 truck drivers, you've got to have a large number, substantial number of trucks.
But here's what I would
And if
say.
they run all over the roads in an area of 300,000 or 500,000 in north central North Carolina, there's a lot of trucks.
And so what I would say to that is that that's over the period.
And that's a big business.
It wasn't a big business, Your Honor, with respect.
Okay.
And that was 450 employees under the entire 2-year time. With again, because it's almost a summary judgment type procedural posture under Berkeley County School District. I mean, the inference is that was with high turnover. It wasn't 450 employees at any one given time. And so the number of trucks, it really wasn't put into the record because, again, we're not looking at the trucks, we're looking at...
So you don't accept the 450 number?
I don't accept the 450.
Well, but you said it was in your complaint.
Well, Your Honor, what I don't accept is that 450 employees at any one given time. I don't believe that
Well, maybe that's right.
450 over what time period?
Over about a 1.5-year time period of when she was actually operating.
What was the highest number that you had at any one time?
Your Honor, I don't...
You don't know.
Because...
You're not entitled to know.
Okay. Our argument is that Amazon controlled those employees directly. Amazon was using the LLC as a pass-through entity so that it could control those employees directly, so it could control Amos directly. It had almost an Orwellian level of control over the employees and Miss Amos. And so to the extent that Amazon was the one who was determining the number of trucks at any one given time. So it wasn't that Miss Amos was independently deciding these things. They were showing up, and she was forced to lease them as part of this model that Amazon was.
She owned the business.
Well, Your Honor, we say that it was really employment, and because of the level of control. And so obviously if you don't accept those facts, if you don't accept that there's control, if you don't accept employment, then at that point, then...
Is it true that she had an offer to sell for $1 million?
Yes, and we also know that Amazon...
Let me ask, I need to follow up on that. So what business, she's just an employee, what business was she selling for would she be selling for $1 million?
And so it would be the relationship with Amazon, and of course Amazon wouldn't let her do that. Amazon...
Well, I'm not asking you that. I'm talking about the nature, the fact that a business was a business entity that could be evaluated on that basis. In other words, she wasn't offering herself as an employee or a worker for sale for $1 million. The offer made to her was to buy the business.
And so that was through a letter of intent, not a firm offer. But I get I just wanted to clarify. I don't. But
that's irrelevant to my question, isn't it?
Yes, sir.
Okay.
Okay. But to the extent that we're looking at it, maybe it could be valued as a business. Amazon wouldn't let her do that. Amazon treated her as an employee, and so even though there was the attempt to go that route, it didn't work. And so in the end, Amazon treated her as an employee all the way through. The facts about control are in the record. They're verified, JA 135. Again, the amount of control that Amazon had over Amos and her co-employees that she managed was to the level of employment. We would have the anomalous situation.
Amazon, let's concede, Amazon had a lot of control. They have a reputation, they have a logo, they have, they're interacting through this business with the public. But every time you say that, you sort of seem to imply that she did not run a business. But she did all the HR. She paid them. She paid them on a basis. She hired them. She directed where they're going and managed the company. And it was a delivery service she was providing for Amazon under, to be sure, a lot of restrictions that Amazon imposed. But there's a lot of difference between a commercial delivery business under those circumstances and an employee as referred to in Section 1 of the FAA. An employment contract is what that refers to as the exception.
May I respond very briefly?
Please do.
So the answer to that is that we're still looking at whether she's an employee of Amazon. If she's an employee of Amazon, she's a worker performing work. Is she doing work for Amazon? Is she doing services for Amazon? That's all that New Prime asks. Through a contract of employment, yes, that's the program agreement. So respectfully, that's our answer to that.
Yeah. All right, thank you, Mr. Weeks.
Thank you.
We'll come down and greet counsel and then proceed. This is sort of new. I think the last term of court we came down and greeted. During the pandemic, we regretted how we weren't able to do that, but we're, as far as I know, we're the only court in the country comes down and we hug and kiss you and we go on to the next case. All right, the next case we'll call today is Maldini versus Accenture. And I guess, Mr. Hellman, you're first up.
Yes, good morning, Your Honor.
Whenever you're ready.
Thank you, and may it please the court. I'm Matthew Hellman from Jenner & Block on behalf of appellant Marriott. At the heart of this case is a fundamental mismatch between the alleged conduct and the alleged harm. Plaintiffs seek to certify classes arising out of a data breach, but they're not bringing identity theft claims because discovery disproved those claims for the class. That led plaintiffs to make a late switch.
Is there, you got the microphone close to you or just?
I can bring it closer, Your Honor. Is that better?
Thank you. That's better.
Yes. I was saying, because identity theft claims aren't borne out here, plaintiffs made a late switch to an overpayment theory. But every one of the would-be plaintiffs who supposedly overpaid agreed not to pursue class relief. And even if they could pursue class relief, there's no way to tell who overpaid because without millions of mini-trials. Nor is there any way to tell how much they overpaid because plaintiffs' damages model is entirely dependent on an improbable assumption that their expert never tested and our expert showed was false.
Is there any case that has suggested that in a data breach, overpayment was a theory? In other words, curiously, neither side cited our Beck case. We cited a few years back, but it was a data breach case, and absent the idea that somebody had to keep monitoring and reading and checking and so forth, we said was not injury.
Correct.
Created standing, and you needed to have an actual somebody using it, using the credit card or using the information. And so it seemed to me that case, I haven't looked at it that closely, but might preclude this overpayment theory, which I have a difficult time understanding. The reason I have a difficult time standing, I would expect that immediately after the disclosure of the breach in 2018, the prices of Marriott would have to drop its prices if the public thought that they were harmed by this. But I saw no claim or suggestion that that happened.
I couldn't agree more, Your Honor, both with that theoretical point and the facts of this case, which show that 90% of the would-be overpayments were reimbursed in this case. You know, this court has talked many times about classes that have a large number of uninjured members.
But you use the word overpayment. You pay $100 for a hotel room, actually probably more like $400, but for a hotel room, and somebody comes in and says, oh, the furniture in that room wasn't as represented. It's not luxury furniture, it's cheap furniture we bought on the off market. And the question is, have they been injured? as recognized in the law? And the answer might be developed by some kind of market study that says people will not rent that room for $400. They'll only rent it for $300 because it's got cheap furniture. But in this case, it's a privacy issue. We agree to keep your data private, and there's a breach. And so now the allegation is, well, we wouldn't have paid the $400 with the fact that a breach occurred. We'll pay less. But there's no claim of that, and there's no evidence of that. Everything I see, even under Prince's model, is they're trying to suggest that the data has independent value of some kind because it can be bought and sold.
Which, of course, the district court found that there was no basis for going forward under that damages theory. And Your Honor, I very much agree. This is to call it a novel theory is maybe to give it too much credit. And particularly on how it comes to this court, you talk about Dr. Prince's model. You know this is an inappropriate theory because look how Dr. Prince tried to measure this would-be overpayment.
Dr. Prince was the plaintiff's expert.
Correct, Your Honor. And this is our third point, but I'm happy to go there if that's where the court has questions to begin.
And there was a Daubert ruling on his evidence.
A Daubert, yes, Your Honor, as well as a Comcast ruling, because of course Comcast is an overlay that applies when you're talking about certification of a class.
And your understanding, just so I'm clear, is that under 23F, we can go beyond the Comcast ruling and also review the Daubert ruling? Because that seems novel also to me.
The way I would put it, Your Honor, is Rule 23F allows you to assess the class certification ruling, and you don't get class certification unless you satisfy Comcast. Comcast, in turn, requires a rigorous assessment of whether the assumptions are reasonable, not speculative, in order to put forth a damages model that's capable of showing class damages. This model decidedly is not, and if I could, I'll just...
So just so I'm clear, yes, we can review the Daubert ruling.
Well, the court brought in his Daubert...
You don't seem to be answering our question.
Yes, Your Honor, in the sense that the Comcast rule, the Rule 23 certification order here incorporated...
Right, I would have thought that what we could review was that we would sort of take the model as the district court credited it and then see whether under Comcast, it's key to the right theory of liability and whether the district court reasonably decided that using this model would allow for class-wide measurements. Yes, it would require some individual inputs, but more or less it's a class-wide measurement. But you don't think we sort of take the model as the district court credited it as our starting point?
I don't think you do that, Your Honor, because you have an independent obligation to determine whether or not...
Well, I was the one that caused the problem when I raised it earlier, because you had other issues about the ability to identify class members. I was trying to get to a more fundamental question of whether they're standing for the large group that is unable to show or has not been alleged to show injury in the form of some kind of identity theft or something like that.
Right. Correct, Your Honor. And if ever there were a poor case for overpayment, if it could be a theory, it is not. It is this one because 90% of the stays here were reimbursed. So we're not even talking about overpayment. So you really do have.
But those people are not in the class, right? I'm sorry. I thought the class was narrowed to only people who weren't reimbursed.
That is the problem because
you think that makes an ascertainability problem. Can I ask you about class action waivers? Because I understood that to be your first argument.
Sure.
And it does seem like it is a sort of clean legal argument where the pieces aren't still moving compared to some of the other things we're being asked to look at. So I have sort of thought about that one a lot. And I agree with you that it does appear that district courts routinely do what you say they should do, which is decide the waiver issue before certification. But what I have not been able to find, and tell me if it's out there, is there any authority saying you have to do it that way, or anyone decertifying a class because it didn't happen in that order, or is it just that this has become sort of like a customary way for district courts to treat it?
So there's, as you say, a lot of authority dealing with this at the class cert stage. To do it, I'm not aware of a specific case that says it was error generally or always are to wait. But in this case, where you have an MDL, there's no point in waiting. Any case involving these sets of facts, these allegations.
Well, I thought the class that had the class waiver was a very limited part of the 133 million potential class members. They were the ones that at the Hardwood, whatever, Sarwood or whatever it was, hotels, who were members of the select guest program or something, that had that language that you quote.
That's right.
That was the class waiver. So you didn't know who had or potentially would have the waiver until the judge told you what he was going to do as to the inclusion of the class.
That is 100% correct. Yes.
And you got right.
Yes.
So and so he has not ruled on the class waiver.
No, that's right. He seemed to think.
No, you're wanting us. Are you appealing something that he hadn't ruled on? We don't normally do that. You got to lose first.
What we are appealing in the first instance is his delay of the ruling.
The delay of the ruling.
His decision.
But you filed a notice of appeal or something, didn't you? You got it up here.
We did, but the thing that
You filed a petition for appeal, and you were granted. You got this. This is an interlocutory appeal.
It is. That's right, Your Honor.
Yeah.
And one of the things we asked for in this interlocutory appeal is the resolution of the class waiver issue.
Well, but you want us to resolve the class waiver or Judge Grimm to resolve it?
As Judge Harris said, I think this is a clean legal issue that is
But it hasn't been ruled on by the district court.
That is.
And we normally rule on things that the district court has already resolved. We're an appeal. We're a court of review.
Right.
Okay.
And if this court were to send.
Well, you're on the same wavelength, I think. We understand. But you want us to analyze it in the first instance.
We would like you to analyze it in the first instance.
Just to take a little other side of that issue, I think that's a legitimate approach. But the question is a 23F appeal appeals the certification or non-certification of a class. And if the certification depends on whether there's waiver or not, and you raise that below, and the court didn't address it, it seems to me that if it goes to the certification, we can still address it.
Yes, Your Honor.
Because it goes to whether the class should have been certified.
That's right. And this is.
I'm sorry, just so we.
Yeah, right.
Right, because the district court ruled on this, right? The district court said, I don't have to address this now. I'm going to address it at the merits. There's a ruling on that.
That's all. That is correct.
And that's what you're appealing.
And that is
right. And then that seems like a separate question to me from assuming entirely hypothetically that we were to agree with you that the issue needed to be addressed before the class was certified. As Judge King has alluded to, our normal practice would be to send it back to the district court to make the determination in the first instance. Although what you would like us to do, and I think your colleagues too are arguing kind of the merits of that issue, you would like us to address that first, although that would be unusual.
It would be unusual, but it's appropriate in this case because, one, both parties have asked for it. It's a clean legal issue. And the whole point of 23F is to get.
Oh, the thing that I thought was a clean legal issue, just to be clear, I thought it was a clean legal question whether that needed to be determined before the class was certified. I see nothing clean about the underlying question, which seems to turn very much on kind of the fact-specific nature of what happened below and was there a waiver, and then there's enforceability questions, and then I can't even remember all the different questions that have been raised. That doesn't look clean to me. That looks like a big mess.
Well, the key facts are straightforward. We raised the defense in our answer. When they asked us what's the basis for invoking a class waiver, we pointed to this very contract. To Judge King's point, they would not tell us what contracts were at issue.
And your answer was, what, a year and a half after the complaint was filed?
Our answer was, I could get you the day for that, Your Honor, but we timely answered.
Or a year and a half after the complaints were filed? More than a year after the thing went to the MDL or something? You didn't answer. So that's when you raised it. You raised it in as an affirmative defense in the answer.
Correct, Your Honor.
But I would think if you had a class waiver, you'd raised it the first time you ever met Judge Grimm. He wrote you a letter the day they sent it to him from task force up there in Washington assigned it to him and said he was going to talk to the lawyers in a few days or something. You'd have been right out front with this thing. But he hasn't ruled on whether there's a waiver, on the waiver issue, and he hasn't, the class waiver, and he hasn't ruled on whether the defensive class waiver was waived. He hasn't ruled on that. So we're wanting us to rule on all this stuff.
I think both parties.
And I understand.
Yeah, I agree that the issue's teed up.
I know which side you're on, and I know what they want to do. I think I understand. I think.
If I could say just a few more words about the damages model in this case, because
I'm going to ask you one more question about this. If the class, potential class, that this class action waiver applies to, has approximately how many? Of the 133 million, how much did that reduce by?
I believe, as certified, this is a 20 million.
About 20 million.
Yeah.
20 million potential individual lawsuits over overpayments, right?
Well,
In Maryland, because you haven't claimed it had to go to New York, even though you got that in that thing too. You haven't said anything about wanting to go back to New York. You want to stay in Maryland because that's where your headquarters is, probably.
so under New York law, which governs the class action waiver, and really any potentially applicable law, these waivers are enforceable. And and what the law says in this area is it's acceptable to channel these claims to arbitration. And it's surely, if it's acceptable to channel them to arbitration, which could be in any particular form, you could have an arbitral agreement that specifies all sorts of things. It's appropriate to have them also go to the judicial system. Small claims court, for example, is a reasonable way of doing this. But if I could say just a word or two more about if the court's.
I'm so sorry. I just have one more question about this waiver thing. So, sort of, there's no case law saying a district court has to do this before certification. And you were about to tell me why, nevertheless, that really has to be the rule. And why is that?
It has to be the rule because Rule 23 isn't satisfied in a case like this, where Rule 23A asks, is this the kind of suit where someone may sue as a class? They may not if they've agreed not to. It asks whether or not a class action is the superior vehicle for bringing the suit. It isn't if they've agreed not to. It's asked if the class representative can bring claims on behalf of the members of the class. That representative cannot if he or she has agreed to waive class procedures. So we treat this as a Rule 23 question, and on top of the fact that class action waivers are enforceable. And I do think it's cleanly teed up, for Your Honor, for those reasons.
Okay.
I have a larger picture question. The complaint alleges a breach involving 500 million people
Yes,
in all 50 states.
yes.
This action has gone forward with a sample of states and with a sample of issues.
Correct.
So the question I have is, how do Rule 23 requires some form of manageability assessment. What we're talking about now is a group of people who may or may not have been injured by this, who may or may not care, but we involve 500 million people, and because we can't handle that many, we're handling fragments of that, which is going to distort the assessment under 23. Isn't manageability one of the criteria that has to be assessed?
Yes, Your Honor, and that is correct. By the way, it's 500 million stays, not 500 million people, but I take your point that
500 million what?
Stays, hotels.
Stays. Okay, so obviously, sure.
But
Stays.
Overnight.
overnight,
yeah.
trips.
Agreements to stay in a hotel.
180 million people?
I think that
I
sounds
read
about
that
right.
somewhere,
Yeah.
183 million people.
Yeah.
But they're down to 20 million.
Right, because we had a bellwether process which.
And the 20 million are in 4 states. Is that right?
That's correct, Your Honor, yes.
And everyone agreed to this bellwether process, right? That's not disputed or.
That's right. Agreed to the bellwether process. They come forward with claims, the 5 claims they think are best amenable for a resolution to get this massive claims going in the right direction in terms of some answers. We came up with 5 for ourselves. And when that process shook out, all they had is this overpayment theory, novel and unsupported. And on the substance of that overpayment theory, they can't, because this is such a large class, the way they've tried to set it up, they've been forced to assume that hotel prices travel together no matter what. Give me any day, any year, the relationship between the hotel prices will always be the same. That
What Dr. Prince called that theory?
co-movement. Co-movement, Your Honor.
Co-movement.
Co-movement.
Yes, I remember that.
And I would just,
He had a name for it. That's right.
he did have a name for it. Just think about it this way. If this were a single plaintiff lawsuit, someone claiming an overpayment charge for a stay in 2016, and the way the plaintiff said is, I can show you how much I overpaid. I'll take a different kind of room on a different rate from the Marriott 4 years ago and look at it compared to its competitor prices. That's all I'm going to do. I'll just take the 4 year ago price for a suite instead of a double room or whatever, and that will let me figure out the overpayment in the current day. That is what this theory is, times 20 million. And the district court seemed to believe that.
You know, nobody addressed on this theory. It's probably the most troubling part for me is the theory, which has never been done in any case I can see, and it seems to me it's almost looking for the problem. But if you read Clapper and our decision in Beck, you find that it almost has to be rejected as a matter of law. I'll ask your counterparts on that.
But even if, we would be very happy if you did that, but even if the court doesn't go that far.
Did you ask us to do that in your brief?
We did not say overpayment could never be a theory, but we did say that.
So
you
are
don't
you
like the
changing
Prince
your
model.
position then?
I'm agreeing with Judge Niemeyer that
So you're changing your position?
I'm adding that to my position.
I'll tell you one thing that I thought about this case after studying on it, so I'm trying to prepare for this thing. It's a lawyer's paradise.
Well, having lived in it, Your Honor, we could compare notes. But the point I want to make is that even if the court is not as willing, not interested in deciding that question for all time, what it certainly should do is that on this record, where the overpayment is a de minimis, effectively 10% of the class, and the method of proving the overpayment relies on this obviously flawed theory without any support, where our expert went through and just went market by market and said, do these prices co-move? No, they do not. When Marriott prices go up, other prices go down. When Marriott prices...
Right, didn't Judge Graham hire an economist and everything, and there was a long hearing, and I mean, I have to say, I am not an economist, and I did not hire one to help me with this case. So I'm very strong. I have questions about the degree to which we can reach that in the first place under 23F. And on top of that, I got to tell you, like a very strong instinct to defer to the extremely thorough district court judge and then the economist he hired.
Right. I'll answer those questions starting with the last one. I think you can tell Judge Grimm, this was a big case, it was a complicated case. He did ask for help, but he went wrong, and you can see it on the face of the opinion, because in his certification opinion, he says, I can go forward with this because Dr. Prince tested his co-movement theory. Dr. Prince did not test his co-movement theory. That's just a factually incorrect statement. He ran his model assuming co-movement was true. So I too, when I came to this case, said, this is a long opinion. It seems like people spent a lot of time with it. No doubt that that happened, but that's just not correct. And then when you look at what the record is remarkably clean on this point. When you look at Dr. Prince, he didn't try to say that he tested his theory because he didn't. He admitted that he did not. Instead, he just assumed it to be the case. There's only one expert in this case who tested it, and she decisively showed it was not correct. And Comcast does require a rigorous assessment. And with respect to the ordering of the arguments, I don't think this court should say, I don't think it's consistent with Comcast to say that if a court makes a Daubert ruling and then says, because I find things are reasonable, it passes Comcast, that insulates, that turns Comcast into a dead letter, at least wherever expert testimony is considered in a Daubert basis going forward. Comcast is an overlay for Rule 23.
Well, I thought that even if you take, but tell me if I'm wrong, even if you take as sort of a given the Daubert ruling, there are still questions here that the district court did examine about, well, is it really sufficiently class-wide? Because you're going to have to put in all of these individual inputs, and at some point, the individual parts of the calculation might start to overwhelm, the commonality, in which case he said, I will reconsider all of this, which is why I find this kind of frustrating as a moving target. But that seemed to me to be an entirely separate Comcast inquiry that would happen whether or not you can redo the Daubert thing on 23F.
Right. So I think the way to think about this is Comcast itself says it's not enough that the model gives you class-wide damages, because otherwise that would reduce I could come up with any model that gives class-wide damages, right? I could say if your name starts with A, it's $50, it'd be $100. So that yields class-wide damages, but as this court has said in Nucor, for a Comcast opinion, the model has to be based on non-speculative, reasonable assumptions. So that now we're asking, is this model based on reasonable, non-speculative assumptions? I've done a fair number of cases. I can't think of something that's less reasonable and more speculative and in fact disproven than the assumption that's needed for this. And then to your point that he said, well, it won't take that many runs of the model and therefore it's amenable to class treatment. He does say that, but the key that makes that car run is co-movement. If co-movement isn't true, then even Dr. Prince acknowledges he's back to doing millions upon millions of calculations with millions and millions of pieces of data he can't get. No one has that information, and even if you had it, it would the individual questions would predominate to the extreme.
All right, I think we've gone over. Oh, go ahead.
Do you agree with me that all the issues you raised in your brief, we review in this interlocutory appeal, that was your position when you came in here, for abuse of discretion?
That is the standard of review, but this court has made clear that the misapplication of the 23F factors in law is an abuse of discretion. And Comcast talks...
An error of law is an abuse of discretion, but we review everything you challenge in this interlocutory appeal for abuse of discretion.
That is correct, Your Honor, but cases like Comcast...
The but bothers me. Go ahead.
Well, I just want to say that the way that cashes out in practice is cases like Comcast that say you need to make sure that this rigorous assessment on the basis of reasonable, non-speculative assumptions was satisfied. Otherwise, Rule 23 is not, and reversal is appropriate.
All right, thank you, Mr.
Thank you,
Hellman.
Your Honor.
All right, we'll hear Mr. Anderson.
Thank you, and may it please the court. Devin Anderson on behalf of Accenture, addressing certification of the Rule 23C4 issue classes for the negligence claims, which are the only classes and the only claims against my client. After this case made its way through fact and expert discovery, plaintiffs had just one and only one theory of injury as to Accenture, that they had somehow lost revenue from hypothetical sales of their data as a result of the data breach.
Can I ask a question?
Yeah.
I understood that was their only theory for a class-wide injury and damages, but I thought at the motion to dismiss stage, they found that the class reps, at least, or the bellwether plaintiffs, had sufficiently alleged for that stage in the proceedings, other forms of injury as well, but they were individualized.
That's correct. So at the motion to dismiss stage, the district court had found that plaintiffs had adequately pleaded certain other theories of injury related to identity theft.
Right,
But when
mitigation and identity theft.
Correct. So identity theft and sort of related harms like mitigation costs. But when push came to shove and we got the case through fact and expert discovery, and to the point where plaintiffs were going to come forward with their class theories, as to my client, they didn't have overpayment because Accenture
Right, but you're just talking about the class theories now.
I'm talking about the class theories.
Okay, not the individualized. There's still individualized injuries floating out there, but the only class-wide theory of injury over on the negligence side was this overvalue thing.
The lost market value. The lost market value.
Yes,
theory
not
of
right,
harm.
overpayment loss.
And so
And the district court rejected that.
the district court rejected it as a matter of fact, law, and under Rule 702, and then the district court proceeded to say that the damages class action as to the negligence claims failed predominance because fact of injury, causation, damages, et cetera, would overwhelm any common questions. But the district court erred when he decided to nevertheless certify a class action after having concluded that there was no class-wide injury. Whether you look at that through the lens of Rule 23 commonality, predominance, superiority, or Article 3, there's nothing to recommend about a class action at that point once the district court has reached that conclusion. As a matter of Rule 23 in the Walmart v. Dukes case, the Supreme Court held that commonality requires that the plaintiff demonstrate that the class suffer the same injury. And that wasn't a new principle. It goes all the way back to the Supreme Court's decision in the Schlesinger case, where the court recognized you need a shared injury. That's the glue that holds the class together. And so once the district court here, as to the negligence claims, which again are the only claims against my client, found that there was no shared injury, that there was no common injury, the analysis should have stopped. I think that's the clear implication of
But in Walmart, wasn't Walmart like a full damages class? I mean, I understand you don't think that this is a permissible move for the district court at that point, but he didn't certify that. He said, okay, I won't certify that. You don't have a shared injury. I'm only going to certify the things that you do have in common. And from the district court's opinion, it sounds at least as though nobody was really denying that the questions of breach and duty are common questions.
Well, so two responses on that,
Duty and
Your Honor.
breach, yeah.
So on Walmart versus Dukes, I mean, I think Walmart versus Dukes was actually a B2 class. It was an injunctive relief / back pay situation.
Right,
where
but it wasn't,
they
they didn't just do specific elements that they had in common.
That's correct. That's correct. That's not what the plaintiffs were trying to do in Walmart, but I don't think Rule 23C4 provides an end run around the fundamental
Well, that's the
commonality
question, right.
principle that Walmart stands for.
Right, so I mean, I feel like this kind of collapses pretty fast into your argument that, look, you just can't do this under Rule 23, certify issue classes on less than full liability.
I think that's right, and I would say it may get even narrower than that, Judge Harris, because I think you can't do that in a circumstance like this where the district court has already found that the one theory of common harm just doesn't work. That's not a theory of common harm that's going to apply
If he
across
thought there
the
was a
board.
theory of common harm, he wouldn't have done this, right? Then he would have just certified the class.
Well, if he had found a theory of common harm, then I think there may be other issues. I don't know where we would be on that. But by finding that there wasn't a common theory of harm, I do think, and I want to make sure, I know I'm a little over time, but I want to hit
You're over
the
time
Article
already?
3 issues that stem from the way that the court has set this up. So I think a common injury is precisely what sort of turns the abstract legal question about my client's obligations into a concrete case or controversy. If there's not a common harm stemming out.
Why does it, is it okay if I know he's over time? Yeah, so, because I really didn't understand the Article 3 point. The district court, and this goes back to my first question, he did determine that the class reps have adequately alleged individualized injuries, in fact, the mitigation costs and the identity thefts. And then he said, consistent with Lujan, that the defendants will have another chance to contest that under the summary judgment standard, at the right, and demand the right level of proof appropriate for summary judgment at summary judgment. And we know, because these are just issue classes, that no class member is going to recover damages without first establishing injury in fact in a separate proceeding. So I don't see the Article 2 problem unless, are you saying that every single class member has to have suffered injury in fact to certify the class?
I don't think that the court needs to reach the question. So I'm
Okay.
going to work backwards on your questions just here. So I don't think the court needs to reach the question as to whether at the Rule 23 juncture, sort of the question that was left open in TransUnion, whether the class has to prove standing at that
Okay.
point. But I do think there needs to be a mechanism, an opportunity to contest the standing of the class when you have a class claim that's pending against you. And that's precisely what we're not allowed to do. So when
Well, he
the
says
district
it's-
court,
Good.
if you don't mind, Judge Harris,
No, of course.
I think the district court's opinion that you were referencing earlier was talking about the overpayment theory, which was a theory of harm
Oh,
that was certified against.
You mean where he says you can come back on summary judgment?
I believe it's talking about the
It's
overpayment
a
theory.
standalone section called standing. And it
Right.
says, here's how I'm dealing with standing. Right now, I'm going with what I said at the motion to dismiss, and of course, at summary judgment. You think he's not going to allow a test of the class reps for standing at summary judgment?
Well, I don't think the question is he going to allow a test of the class reps? We now have class claims. And I think under TransUnion, at the end of the day, every class member has to have standing. So,
Yeah, and before they get any money, they're going to have to bring a whole separate lawsuit. So I guess at that point, you can challenge standing.
But at that point, we'll have had a binding class determination, right? So, Judge Harris, I think if you play the process out, at least in my mind, the Article 3 problems become evident. So let's play it out. Let's say either at summary judgment or in a jury trial, a jury finds that Accenture owed a duty to this class and breached that duty. That determination purports to bind tens of millions, maybe 100 millions of class members as well as my client. But we're only ever going to address whether that purported legal infraction resulted in harm to individuals if they show up for this second trial. And plaintiffs themselves have said, given sort of the extremely small dollar amount that could be attributed to this, only lunatics are going to ever show up and actually do an individual trial, especially here where we've got significant and complex questions of injury and causation and damages remain. So we're never going to have an up or down determination as to whether the class has standing. And if my client were to win in this issue class proceeding, then standing won't and can't have ever been adjudicated for anybody at all. Either way, go ahead.
I'm sorry. Can I ask one more question? It's not related to standing. I'm sorry. You had so little time. I just, before you sit down, I have a question that is not addressed in the briefing. It's about superiority. And I'm trying to tie all of the pieces of this case together. There's this question that your colleague argued about the class action waivers. If, hypothetically, I thought that the district court should have determined the waiver question before the class was certified, and so that's a problem now with the Marriott class certifications. It seemed to me that the district court's superiority analysis rested entirely on the existence of the Marriott classes. Because as you point out in your brief, like once you've stripped a class down to these relatively small things it has in common and left so much for the individualized trials, it's not really obvious anymore that this is a superior method and it's an efficient method. So the district court relied very heavily on the existence of the Marriott classes to show superiority. So my question is, if I thought hypothetically there were a problem with the Marriott classes because of the class action waiver, would it follow that we'd have to send back the superiority question too?
So I think that's certainly a permissible route because I agree with your characterization, Judge Harris, that the district court's superiority analysis was like, well, we're doing the Marriott thing anyway, and so why not resolve a couple interesting questions as to Accenture's obligations? And so I think that superiority analysis wouldn't work anymore if the court were to reverse or vacate the certification order as to Marriott. But I think the court can go ahead and say, look, in a circumstance like this, it's not just that the class procedure against my client won't resolve liability, although many district courts, including many within the circuit, have recognized that, look, if we can't carry the football at least all the way through on liability, this is not a superior way of proceeding. But it's that the significance and complexity of the issues that remain for determination, this is not some sort of show up at the end of the game with a claims form process after liability has been adjudicated and there's a class-wide damages figure. As the district court recognized, there's going to be significant and complex legal, factual, and expert issues that would have to be presented in any one of these potentially tens of millions of follows-on cases that in order to actually produce anything resembling a liability determination. And so for these reasons, unless the court has any other questions, we would ask that the court reverse the certification of the C4 classes as well. I'll reserve the rest of my time.
All right, thank you, Mr. Anderson. All right, Ms. Keller.
Yes, good morning, Your Honors, and may it please the court. My name is Amy Keller, and I represent the plaintiff appellees in this case. I want to begin by acknowledging that there are three things that are completely unrefuted in the record. Marriott and Accenture had wholly deficient data security. Neither one of them rebutted our expert report on that issue. And indeed, our expert report even discuss the increased likelihood of harm and the additional risks that the class would face as a result of the data breach. Again, the report is unrebutted.
You know, it's curious that you make that claim and never cited Beck, and we addressed that precise issue. And we basically said, and I think we relied on Clapper too, but I can't remember. But the notion that somebody, when there's a data breach, I've been the subject, I guess, of 3 or 4 of them, I guess, I don't know. I have not yet been affected. And under Beck, I have not been injured, and those cases do not go forward. And our circuit's not alone on that. And so the notion that when we have a large data breach that there's automatically going to be damage is unsustainable. It's got to be, there's got to be some theory of damage, and the damage theory is that the data breach leads to use of the data in some fashion that hurts the person. And while you have a plaintiff that's alleged that, seems to me that's fine. But for the class-wide treatment, the only theory is this overpayment theory, as far as I can tell.
Well, Your Honor, after the court decided Beck, it decided Hutton. Beck was a stolen laptop case.
Yeah.
Hutton talks about what happens when hackers target highly sensitive personal information and how that information can be misused. Yes, as you state, in the record it shows that plaintiffs actually experienced fraud and identity theft, okay? And then we also have in the record the expert report of Mary France, which talks about what happens to the class when hackers target highly sensitive personal information and what damages the class can sustain as a result of their injuries as a result of hackers targeting
But the
highly
issue is
sensitive
not
personal
what they can sustain, it's what they have sustained. In other words, injury, you don't bring torts on the damage actions on the prospect of being damaged. You have to allege you have been damaged, injured.
And there are other forms of injuries in this case, Your Honor, which the court discussed.
Well, I'm talking about the class. We're just talking about the class, and the class injury is overpayment. That's the only injury I see it's left.
But we also have presently pending before the district court, where the district court has granted us additional discovery, where the C4 class can become a B3 class, discovery on the value of personal information. Yes, Dr. Prince had 2 damages theories that he was examining. Not only overpayment, right, which is what the difference you would have paid had you known that the hotel security was inadequate, but also the valuation of personal information, the value that you lost as a result of this data breach. Now, the district court did certify a C4 class to proceed on these issues, but the district court also reserved judgment because we can still present a damages model and present it for B3 certification later.
But the idea that it's all this perspective, everything's been postponed, but we have determinations that have to be made at the present time. If you had a 12B6 and you said, oh, at trial, I'm going to demonstrate damages, or it could happen in the future, or these other determinations, waiver, I'll determine them in the future. A 12B6 says, what is the status now? And a class certification requires a similar type of a notion that it's a very unusual process, and it's a very expensive process, and it's very cumbersome to the judicial system. And it seems to me that there ought to be a rigorous analysis under Rule 23, all the elements to get there. And the notion that we have a changing theory of damages, we don't even know if anybody's been damaged under this theory because they haven't yet tested the full model. I mean, this, I don't know where this leads, but it's a bunch of, a certification may just be too early. Maybe we should be having this go forward, having a mini trial on damage, have somebody decide whether that is a legitimate theory, but to raise for a first time this huge litigation, a theory that's never been recognized in any court, and is not fully developed even in itself. They still have to run analyses. They have to still demonstrate this co-movement presumption, so forth. It seems time we got a little backwards. That's what maybe
Sure.
not. But.
Sure, Your Honor, and that's why plaintiffs did not seek a review under 23F. We do think that it's a little too early.
I know, but the certification has occurred. 23F kicks in once there's a certification order.
Of course. And to address your questions, okay, yes, Dr. Prince had two damages theories, and you were asking about how certain damages theory hasn't been recognized. But overpayment is an accepted damages methodology for a breach of contract claim. This is just a breach of contract claim. So saying that overpayment is somehow not an accepted theory is actually incorrect. As to the valuation of personal...
Well, see, it's overpayment is if you overpay for the room or you overpay for an automobile because something wasn't there that was promised.
Correct.
It's got to be material, it's got to be meaningful. So the question is, the furniture or the carpeting is not up to snuff, and you learn later that the hotel misrepresented the level of that, yet the hotel continues to get the fees for that hotel. People who live there come there and repeat themselves. You got to demonstrate actual injury. It's so collateral. The promise of privacy is sure. It's a service. Everybody wants to have privacy, and with every hotel and all your data, whenever you give data to anybody. But the question is the price of the hotel room in any way geared to that privacy promise and the breach of the private promise?
And I'm glad you brought that up, Your Honor, because that may conflate injury with damages. We know that at the point every single class member made a hotel reservation, they were injured because they were not given the data security that was promised to them. So in this respect, we think that Judge Grimm's class certification decision is actually a little narrow when he certified the subclass, but that does not take away from the fact that he should be entitled deference. Deference, which you, Judge Niermeyer, said in Zetia, district court judges should be afforded. Let's walk through what Judge Grimm did. He had a full-day confab with all of the parties' experts. He hired his own economists, for which the parties paid, to help him analyze the expert report and the theory of damages. He even hired a special master to help him deal with some of the discovery issues that were going to lead into some of these damages models. So when we talk about deference given to the district court, it's very difficult to say that Judge Grimm abused his discretion in finding that this damages methodology was supported by the record. Now, I want to turn to a couple of other issues that have been raised by Marriott's and also Accenture's argument. We brought up the issue of the choice of law and venue provision in the Marriott terms and conditions. Now, that choice of law and venue provision provided that these cases had to be tried individually, not as a class action, in New York State Court or federal court, and based on New York law. And since the inception of this case, we have been treating these claims collectively as a class action. We engaged in a bellwether process where the parties selected claims that would proceed forward, not just at the motion to dismiss phase, but at the class certification phase. Marriott did not bring up the choice of law and venue clause
Counsel,
at the bellwether process.
I'm sorry to interrupt you. So, as I understand it, just I always have like an outline in my head. This is your argument for why the class action waivers were waived.
Correct.
Okay. You are not arguing in your brief, as far as I can tell, there's no actual sort of substantive argument that the district court shouldn't have addressed this question before it certified the class. Like you say it in a phrase, but there's no argument. So you're, as far as I can tell, conceding the district court should have addressed this before it certified the class, and moving on to explain why, when the district court addressed it, it should have found, as it suggested, that this was waived. But you are conceding the district court, or at least you are not. Tell me, what is your position on did the district court have to make this determination before it certified the class?
Normally, these issues need to be determined by the district court, especially here because Judge Grimm was the judge that has been overseeing this litigation for the past 3 years. Now, he found that they likely did waive it because they engaged in all of this litigation activity before even bringing it up. And when they brought it up, it was in a boilerplate.
That's a strange argument, you know, because the federal rules of procedure say that waiver has to be raised in your answer as an affirmative defense. That's the first requirement. You can raise it in a 12b6, but the pleading rules allow you to raise it and preserve it by an affirmative defense in the answer, and they did raise it in the answer. And the district court didn't talk about it being waived. The district court had it before it and just chose not to decide it at this point. To me, and I'm only speaking for myself, but I'm an old proceduralist, and I can tell you that would set the world on fire if we started saying somebody raised an affirmative defense, the district court addressed it, and now it was deemed waived because it wasn't raised earlier in the proceedings. I mean, it just doesn't fly.
Well, while that may be true for other cases, when you look at to whether a party waived a contractual provision, you are allowed to look at what the party did in litigation. And if it was inconsistent.
You'd have to have a judicial waiver, and they would have to say we're no longer raising it. And there's a lot of cases on that type of thing. Otherwise, we don't impute that people waive things when they affirmatively raised them in the pleadings as dictated by the rules.
But the district court importantly found that they likely did waive. And to Judge Harris's point, the district court is the entity.
He can make that finding, and that could be reviewed.
You're talking about a reference in a footnote?
Yes, the reference in the footnote at Joint
Page 25 or something?
565.
What is it?
Joint Appendix, page 565. Plaintiffs raised a strong argument that defendants have waived their right to enforce the class action waiver.
Yeah, page 25 of his opinion.
Yes,
He said they raised a strong argument.
correct. But
He didn't say they waived anything.
that is correct, Your Honor.
You can have a good argument and lose it.
I'm sorry,
There've
Your
been a
Honor.
lot of people, been a lot of parties come through here with cases with good arguments. They end up losing.
Sure, Your Honor.
So
And
the fact that the judge thought he had a decent argument or a strong argument, I don't think supports a contention now that Judge Grimm ruled that they waived it.
Well, important, that goes to
And
my.
as Judge Niemeyer said, they raised it in their answer.
They raised it in their answer, but again, Judge Grimm, who is the one closest to the litigation, who's been overseeing this case for the past 3 years, said we waived a good argument, or we raised a good argument, and he has not yet decided it. The district court in the first instance is typically the entity that decides these issues. And
I understand that, and he didn't decide it.
No,
But
he did
in that same footnote, 2/3 of the way down, he says, therefore, the court may address the class action waiver defense, dash, as it will all affirmative defendants, dash, at the merits stage of the litigation.
Correct.
He decided that he was not going to address the waiver,
Correct.
the waiver of the class action waiver.
Which is why it would be,
And so, and you all want us to decide it now.
no, Your Honor.
I thought
do
when
not.
they said that everybody agreed that we should do that.
That's incorrect, Your Honor.
All right, it's just, they're the only ones, so you're speaking for yourself.
So what do you want us-
That's good. That's what the way the adversary system works.
Well, what do you want us to do? So you agree the district court should have made this determination?
Yes.
And you don't think we should make it now, so you want us to vacate and send it back for the district court to make this determination?
Right, because you can make
Okay.
a
So
determination.
you're asking
that's
for
a
a
big-
remand
Okay.
rather than an affirmance?
No, we think that the district court did not abuse its discretion in certifying any of these classes.
So you want us to,
Just said.
so what do you want us to do today?
We want you to affirm, and we want you to remand for the case.
To
to
affirm and remand because it's an
Correct.
interlocutory appeal,
Correct.
affirm and remand for further proceedings.
Correct.
But
And
I don't
apologize,
understand.
Judge Harris, if I was confused by your question.
Okay. I thought your position was the district court did need to make this determination before it certified the class.
And I apologize.
That's not your
before-
position.
Not before certification. In the
Okay.
first instance,
How come there's nothing in your brief that explains why the district court didn't have to make this determination in the first instance? I don't see that argument in your brief, and normally we would say if you don't argue it in your brief, you have waived it.
Fair enough, Your Honor. So the district court the district court did not need to determine this prior to class certification because all of the issues are same in front of the class, right? So we look at the contracts are the same. The issues can be decided as the case proceeds.
Okay,
forward.
but I have two questions about that. The first one is, since you didn't make that argument in your brief, why should I not consider it waived?
Because, Your Honor, when you look at whether or not the district court abused its discretion, which is why.
I understand, but normally you're supposed to make the argument in your brief, and you don't. There's like 2 words saying district court management of the docket, and then lots and lots of pages about the merits of the class action waiver issue, and I am concerned about that. And I guess my second question would be, why on earth would the district court not have to do this before he certifies the class? I don't understand that. If the point of the class action waiver from Marriott's perspective is, it's not that, well, we got this waiver, so phew, after we litigate a gigantic class action to summary judgment, we will win. It's that we're not going to have to litigate a gigantic class action, and if you don't make the determination before certification, how is this waiver of any use to Marriott?
And I appreciate that, Your Honor. I think it's because all of the issues are pretty intertwined, right? Because we argue waiver, right? And because we argue that Marriott has waived, and the district court found that they likely did waive.
You're talking about, the term waiver is getting thrown around.
I know,
You're talking
Your
about waiver of the waiver.
Good, yes. Waiver of the choice of law and venue provision. And importantly, like when you look at the actual record, it's whether or not Marriott acted inconsistently with the choice of law and venue provision. And that is something that the district court is within its discretion to determine. We don't think it needs to be determined prior to certification of the class action. And I do want to note that the very specific language in the choice of law and venue provision says that any disputes arising out of or relate to the SPG program or these SPG terms will be handled individually and without class action. If they were supposed to be handled individually and without class action, then why did Marriott engage in the entire bellwether process? And the other note that we make in our brief is whether or not the parties can contract to take away powers from the district court. If the ship had already sailed on Marriott engaging in the bellwether process as part of a class action, the parties cannot then take away power from the district court and tell the district court what it can and cannot do. Just like the parties, as we talk about in our brief, cannot say the Rule 11 doesn't apply to the proceedings. We can't tell the district court whether or not to make certain determinations on established federal rules of civil procedure. And that's one of the arguments that we do make in our brief that I think is very important.
Okay, but why doesn't the district court have to certify this before, why doesn't the district court have to determine whether these putative class members may bring a class action before he certifies them as a class? Just logically speaking, I'm just not getting it.
I understand that, Your Honor. And importantly, Marriott could have moved.
But I understand you have this like waiver issue, and I do fully, I think it is a complicated question. I do think I understand your arguments on that point. But what I don't get, because again, it's not in the brief, is what would be the argument for why this all need not be determined prior to certification?
Because on a class-wide basis, Your Honor, we don't think that Marriott has the ability to tell the district court what it can and cannot do pursuant to the actual terms.
It's not telling them what to do, it's making an analysis of whether a person qualifies commonality. I mean, if a person has an individual defense, or Marriott has an individual defense against somebody and said that you have to decide this in this way, in this court, in this venue, and so forth.
That would make sense, Your Honor, if the plaintiffs had agreed to something like, I agree not to be a class representative. I agree not to take part in a class action. This says will be handled individually and without class action. Will be handled by whom?
Yeah, well, can't that be decided by the district court?
Again, and it should be decided by the district court. We don't think it's.
You don't want us deciding it.
We don't think it's necessary. First of all, we don't think it's necessary. We don't think it's appropriate for this court to decide it in the first instance. But we also think that there's enough in the record that if the court were to determine that waiver happened, there's enough in the record to.
Am I wrong that this only applies to the Starwood special guests or whatever the thing's called?
Yes, the SPG
Okay, so it
program.
only applies to the ones that are in this class. So
Correct.
So it's like a chicken and
Subclass.
egg. He had to define the class to know who had the class action waiver.
The subclass, Your Honor.
Well, the subclass, but as it's the 20 million have a class action waiver. If it had been any broader than that, there'd been a part of them would have had the class action waiver and part of them wouldn't have. Is that right?
Correct, Your Honor, but
This contract provision that you're fighting over,
yes,
that includes the class action waiver,
yes.
as I understand it, applies to the special guests, or whatever they're called, of Starwood.
That is
Before
correct.
it was bought by, or when it was, after it was bought by Marriott, right?
Right, and the class period is from 2014 to 2018.
But I thought you would argue that would be a reason for him to do it in this, the way he did it, Judge Grimm, that he had to identify this Starwood class before he could get to the question of the class action waiver, or possibly get to it. That's where he puts his footnote, I think, where he has it in his opinion. That footnote 26 that you were talking about a while ago.
And that is correct, Your Honor, because determining who is governed by the SPG terms and conditions is necessary to determine who would be a member of that subclass. And Judge Harris, I know you furrowed your brow when I said subclass. Again, and this all just goes to the fact that this is a very complicated issue.
That's the first time that term's been used today, I think.
And I thought all class members, aren't all class members members of the SPG program? I thought that Judge Grimm did that. He said, to avoid these commonality issues, I'm kicking out everybody who's not a member of this program. The only class members before us have signed this class waiver, right?
Correct. As
Okay.
to the breach of contract claims, yes. But recall, when I talk about subclass, the reason why I said subclass, because that's what he certified. The reason why I said subclass is because there's still a broader class that would encompass broader claims. Those are the B3 claims on the valuation of personal information.
Which are not in front of us now.
No, but
Okay.
that relates to the C4 classes that have been certified, because it's our intention to go back to the district court and
Right, but as of now, all members of the C4 classes that were certified in this order are members of that Starwood program, right?
that is correct, Your
Okay,
Honor.
so all the class members currently in classes have signed that class action waiver.
Yes, because
Okay.
they are SPG members as they
And that's 20 million people, is that, or 5 million?
Well, the reason why, well, first of all, Your Honor, we have to rely upon Marriott's representations for that, because they refused to give us the database that had all of the stays before the class was certified. So we have information on our named plaintiffs, and we're relying upon Marriott's representations as to the class size. That's the 20 million. That's the breach of
So
contract.
currently, based on the reduction to the 4 states or 5 states or whatever, and the bellwether issues, we have certifications that cover roughly 20 million people. That's the number we're using. And all of those were part of the Starwood program.
That's correct, Your Honor. And I noticed that I'm out of time, but I did briefly, you had asked about the bellwether process and about manageability. And I was hoping that I
Yeah.
could address that. So as part of the MDL process, and as I understand it, a lot of judges are adopting this now. When you have a large case as part of an MDL, the judges may ask the parties to engage in a bellwether process, picking their strongest claims from certain states so that the briefing before the judge can be narrowed to allow the case to be streamlined and proceed forward quickly. Importantly, a lot of the issues that are decided in the bellwether claims can decide the issues in the other class claims. That's the reason why the parties engage in a negotiation to pick representative claims, right? Because certain claims for state consumer protection laws in Oregon, for example, may decide certain issues with regard to.
But my question, I understand your point, and it's well taken. My point was a much broader question, and the question was the whole bellwether process. When you are purporting to represent hundreds of millions, or 180 million or 200 million people or whatever, you need to narrow it down to a few states, so representative states, and then representative issues. I don't know how many we have, 13 or 12 representative issues,
Well, Your Honor,
bellwether issues.
bellwether issues. So we determined it by claims.
Yeah, by claims.
And there were 10 claims initially. We lost on a motion to dismiss, I believe, one of those claims. The court did not certify every single one of the bellwether claims. It denied the motion to certify the Michigan class without prejudice as to the loss of valuation appeal.
All right, I'm not so interested in that. What I'm interested in is the notion that we have to go through this process in order to manage the case raises a fundamental issue for me as to whether we can have a class action at all. This would be really for the professors to write about, but I can tell you I was chair of the Rules Committee, and we had hearings for about 2 or 3 years on class actions. And I heard from all of you on the plaintiff side, all the defendant side, I heard all the professors, and the philosophical questions about this management and the size of classes. You know, remember Castana was, 50 million people, and this is much larger. This may be the largest class action I've ever seen. And so the question is, if we have to go through that process, aren't we defeating the class action or violating the class action rule itself in that sense? I mean, the class action rule is not the head. The class action rule's the tail. And the head are the individual plaintiffs who are purporting to represent others who are similarly situated. And so when you think in those terms and you say, we can't handle this unless we narrow it all down. We couldn't handle the 50 states and the 100 and 200 million people claims under all kinds of factual circumstances. We'd have so many subclasses and so forth. My question was, and probably doesn't need an answer from you because maybe this isn't the right place to talk about it, but if we have to go through this process that's going through, this very orderly process and reasonable process from good attorneys on both sides, to narrow it down and to go to bellwether issues and to get samplings, we're basically conceding that otherwise it would be unmanageable. And one of the main things about class actions is not legislation for all of society. That was my question, and it still concerns me. This case raises it more than ever I've seen, so I don't know if it's a place to address it.
Sure, and we haven't really briefed the manageability of bellwethers and things like that, but there's ample support for it in the Manual for Complex Litigation.
Well, I know, but doesn't make it right.
Fair enough, Your Honor, but we also know that trials can proceed on a narrower set of claims. We just saw the Squateros versus GM trial proceed forward where there were a limited number of claims and there are still other claims outstanding against GM related to the same defect. We get the sample from, say, for example, mass torts where they pick bellwether claims to proceed forward. So this doesn't mean that it's unmanageable. In fact, in Tyson versus Buafeco, the Supreme Court said you can engage in sampling to support class certification claims.
I know, but when you're doing sampling, that's a mighty dicey, risky process.
Which isn't here, Your Honor.
Okay.
But importantly, this just goes to the point you made in Zetia, which is the district court should be afforded discretion because the district court is the one seeing the case in, day out. Judge Grimm,
Well, he is, but you know, he kept putting off issues. And some of them, the question is, can he put them off? Because you're launching into a huge battle, so to speak. And if it's, in the end, not going to be justified, then you have those enormous expenditures of judicial assets as well as party assets. And so I think the notion that you ought to have a rigorous analysis up front is very meritorious. Now, whether this case is a violation or not, that's the question, one of the questions we have before us. But I raise this. I mean, sure, there can be sampling, but yet be cautious in sampling. We do, every time you have a market study in connection with trademarks and so forth, we do sampling. It's done many times, and you can impute. But when you actually have a process, which the only way you can really handle it is with sampling, then you have to start asking the questions whether the process allows that in the big picture. Now you say they're doing it, fair enough, you'd have to look at each one. But this case is huge.
And I appreciate that, Your Honor. But importantly, we have to look at the fact that both parties consented to the bellwether process. So when we talk about an enormous use of resources and everything, which by the way has already occurred, the parties already engaged in 18 months of discovery to get to this point and worked with a special master on discovery issues and again with the economists that Judge Grimm hired. But importantly, both parties consented to the bellwether process and did not object to the fact that this somehow made the classes unmanageable.
But if you're going to go to the bellwether process, then you've got to make it work, which means make the decisions on anything that's material. And to go through a bellwether process and leave open four important matters and say, I'm going to decide those later in some larger context, which could defeat the whole process, defeats the bellwether process. And so I just raise this abstractly, although I must say some of these concerns linger as I read this case, and I'm not sure what an appellate court's supposed to do. I'm not sure Judge Grimm is supposed to do. Incidentally, you know, Judge Grimm's down at Duke now, and do we have a new judge appointed on this?
We do, Judge Gallagher, and she
Judge Gallagher, okay, yeah.
She has made a couple of decisions already with regard to discovery that's pending before the district court, which we've asked to supplement the record on. And, you know, of course, Your Honor, these are really tricky questions that are being examined by people that are far smarter than me on the bellwether claims. But it's important that we
You don't need to self-deprecate. You've demonstrated yourself well.
Well, I defer to Judge Grimm and on these issues, and I believe that this court should defer to him.
No, I'm going to ask one more question. If I can. And this follows up the question from Judge Harris. On that class action waiver, did you all ever, you talked about all the cooperation and everything, did the parties ever jointly ask him to finish the job on the applicability of the class action waiver? Because you must have anticipated there was going to be an interlocutory appeal on the certification, that everybody had been better off if you'd had the resolution of the class action waiver issues before it came up here.
Well, I believe, Your Honor, that is what we initially argued as to why the 23F shouldn't be granted. Marriott moved for a 23F before we could do any of these things before the district.
I understand. They wanted to come on up.
Yeah.
So there was no joint request or effort unilaterally from either side to try to get Judge Grimm to resolve that point before the interlocutory appeal got here.
That is correct, Your Honor.
Well, it would have helped us. I don't know. I'm speaking for myself. It would have helped me a lot if that had been resolved.
I agree, Your Honor.
I just have one more question, and I know we've extended both of you quite a while, but this is a fairly significant matter. Marriott raises the point that Dr. Prince presumed co-movement and had not yet demonstrated it, and his argument rested on his ability to demonstrate that at a later time. What's your take on that?
We disagree, and we think,
that's what I thought you might. Let me hear
yeah,
what you
sure. No, we think it's adequately supported in the record that Dr. Prince rigorously demonstrated his damages model. And
No, not the model. I'm talking about co-movement. He relied on co-movement of pricing among hotels.
Correct.
But he had not yet, he acknowledged he had not yet tested that. He had not demonstrated that yet.
But importantly, Your Honor, co-movement, and I'm not an economist. I don't know if there's any economists in the room like the one that Judge Grimm hired to help him with this. But co-movement analyzes the rather unremarkable principle that hotel prices are competitive, right? And that they tend to move together. So if Marriott...
But he assumed that.
Based upon...
He assumed that, and the expert on the opposite side said that's not so because of various conditions and market conditions, some logic. But my question was, the argument that Marriott makes is that the model depends on that assumption, which has not yet been demonstrated. And I wonder whether you agree with that.
But the model relies upon accepted academic literature. And again, this is an issue.
On co-movement?
On co-movement.
There's got to be some data on that, right?
But Dr. Prince not only cited to academic literature, but we also have a chart in our appellate brief which tracks the fact that hotel prices generally move together. I cannot recall the page offhand, but there is a chart which we submitted to the district court showing that co-movement is an accepted principle of economics.
Okay.
And again, Dr. Prince, the analysis of his expert report, it was assisted by Judge Grimm because he hired an economist. And we had a full day expert confab, to which this court doesn't have the benefit, right? Judge Grimm had the benefit of consulting with that economist. And Judge Grimm did not abuse his discretion at the end of the day. It's inappropriate to relitigate this Daubert issue on a Rule 23F appeal. And unless the court has any additional questions, I see that I've well exhausted my time, and I thank the court for its time.
Well, thank you. Thank you for your argument. All right, we have a few short rebuttals. Let's start with, I guess we start with Mr. Hellman.
Yes, thank you, Your Honor. I will be brief. This is a large case, maybe an unprecedentedly large case, and there are a lot of issues in it, both theoretical and, I would say, expressly argued in the briefs. It would be most helpful and appropriate for this court, which has discretion in the issues that it will address here, to begin with Dr. Prince and the co-movement theory. And I say that because that issue has gone all the way through the process of class certification, and for the reasons I've said before, it was never tested. My friends on the other side said, look at the chart we submitted. The chart is of 7 hotels that have no bearing in this case. They're not Marriott properties or any other hotel at issue in this case. There were charts submitted in this case by the one expert who did test the co-movement assumption. That was our expert, and she showed that for every market at issue, co-movement did not take place. Comcast requires more. You should reverse on the basis of Comcast.
Let me take the logic through just of your argument. So your argument is Dr. Prince's theory is not sufficiently tested at this point.
It relies on a speculative assumption.
Yeah, on a speculative at this point. Now, his argument, just come back, I'm going to grant you that. His argument would be, oh, I'm going to demonstrate that and I'll bring data in. But let's say right now it's at that point. What does that lead to in terms of what we should be doing?
It leads to reversal.
Well, not the general, particularly. What issue does that hit?
That issue means that certification was improper because you need to show that your model is adequate to obtain certification. You can't show it afterwards. And let's just...
Under what 23B1? B3?
So Comcast is born out of the predominance requirement because otherwise common issues don't predominate. And where your model isn't capable of reasonably on a reliable basis showing damages, you haven't satisfied predominance. That's line and verse from the Comcast decision. And if I could, there is no future day on which Dr. Prince is going to be able to show co-movement, because to do it, as he tried, we actually can look to the past, not to the future on this. His original report said, I will obtain the prices for all of these competitor hotels and run the analysis every time for every stay over 4 years for every kind of room that's at issue. That data doesn't exist. Marriott doesn't have it. Marriott doesn't have its competitors' prices. He can't get it. And that's why he went to his simplifying assumption, which was a necessary assumption for him, but speculative and unreasonable all the same. And that issue has gone as far as it possibly could at this point. And if Rule 23F exists for anything, and again, we talk about deference to the district court, well, there's also an unusual right of interlocutory appeal, or I should say an avenue for interlocutory appeal. This is the case where the rigorous analysis that Comcast requires is not met. And I think the most useful thing in this aquarium of problems that this case presents, the biggest fish, the one that would be the most helpful to reach, would be the Comcast issue. Now,
Okay. I think your time's up. And you have anything else that is important, that would help, but
I just want to say, we believe that the issue of the waiver is squarely teed up, ready for this court, but we'll rest on our briefs on that. I think you've heard our position on that, unless the court has questions.
all right, Mr. Anderson.
Thank you.
The chart here says you have 1 minute.
I'll take that as a challenge, Your Honor. I actually didn't hear very much in defense of the Rule 23C4 issue classes in the presentation from the other side, so I'll just say this. In Beck v. McDonald, the case that Your Honor was referencing earlier, this court recognized that for someone to have a claim coming out of a data breach, they need to not just say there was a data breach. They have to translate the alleged negligent act into an actual felt harm. Plaintiffs took a swing at that as to my client with this lost revenue of sales theory. The district court rejected that. There is nothing on the table at this point, and it cannot be a superior mechanism for adjudicating this case to have a miniature class action that moves the ball 10 yards down the field and says good luck to individual plaintiffs who want to take the ball the additional 90 yards to the end zone. That cannot satisfy the superiority requirement of Rule 23B. I don't think when you lack a common injury that you satisfy commonality or predominance either under the Supreme Court's precedents.
Can I ask just a very quick clarifying question, because I have to say the size of this record defeated me. Before the district court, which of the issue class arguments did you raise? The ones in your brief? I mean, is if I group them as there's no Article 3 standing, Rule 23 doesn't allow for this, this fine a cut on issue classes, and it's not superior. Were all three of those issues in front of you argued all three of those issues in front of the district court?
Yes, we did, Your Honor.
Okay.
I do think one thing that became clear, though, is when plaintiffs moved for class,
Did he rule on all of them?
he did not rule on all of them.
So you're here without, you don't have a ruling to appeal from?
We definitely do, Your Honor.
Well, you say you didn't rule on them.
He didn't. He ruled on the appropriateness of class treatment of these particular issues. But when plaintiffs moved to certify their case, they moved to certify liability only.
Yeah.
And then the district court sort of sua
Cut it
sponte
down
took out the
further.
carving knife and started carving off some issues.
Okay.
And so,
But you did make the argument before the district court, look, putting to one side Article 3 and putting to one side for a minute superiority, just Rule 23 does not allow for a class on elements that fall short of full liability.
that's correct, Your Honor.
Okay.
And we said, look, when there's not a common injury, you can't have a class action of any kind, whether you look at Rule 23A, B, or C.
Okay.
For those reasons, I would ask that the court reverse. Thank you.
All right, thank you. All right, we'll take a short break. We'll come down and greet counsel first, though, and then proceed to the last. All right, be seated, please. Next case we'll call, final case this morning is Rogers versus Tug Hill Operating. And Ms. Birch, we'll hear from you first.
Thank you, Your Honor. Good morning, and may it please the court. My name is Rex Birch, and I represent Mr. Rogers in this appeal. The Supreme Court tells us that there is nothing in the Federal Arbitration Act that authorizes a court to compel arbitration by any parties that are not already covered by the contract, the agreement, the arbitration agreement. The district court therefore erred in holding Tug Hill could force Mr. Rogers to arbitrate with Tug Hill based on an agreement between Mr. Rogers and an independent company called Rigup, without Tug Hill having to prove that it was somehow authorized to enforce that agreement. The district court's error is not remedied by the district court's, my friends call it alternative holding, that Tug Hill could enforce the arbitration agreement under West Virginia state law as a third-party beneficiary. Mr. Rogers showed, and indeed at Joint Appendix 18, paragraph 11, Rigup itself testified that Rigup included the arbitration provision for its own benefits, not, quote, solely for Tug Hill's benefit. When Rogers raised West Virginia Code Section 55-8-12, which is the third-party beneficiary statute governing contracts in West Virginia, the district court analyzed the question of what it meant what the word sole meant in that statute, but it answered the wrong question. The district court determined that the word sole did not mean that there could only be one third-party beneficiary. Again, that's not the right question. The question is whether or not the provision is for the third-party beneficiary's, quote, sole benefit. And again, Rogers showed and Rigup testified as to the benefits that Rigup received by requesting arbitration. Finally, the district court erred when it permitted Rigup to intervene. Let's start with the easiest reasons. In the contract found at Joint Appendix 21 at paragraph 5, folks at Rigup said, any interactions or disputes between you and a company, in this instance it would be Tug Hill, are solely between you and that company. It goes on further at Joint Appendix 23 at paragraph 11, Rigup will not be a party to disputes or negotiations of disputes between you and companies, which in that contract means the folks at Tug Hill.
Can I just ask you a very practical question about intervention? And I'm trying to think of a non-colloquial way of putting this. Like, what's the damage? Why do you care if? Why does it matter so much whether or not Rigup intervenes in this proceeding, from your perspective?
So it increases the burden on Mr. Rogers, not in the legal sense of the word, but just in the practical sense of the word. The folks at Rigup said, hey, we're staying out. We will quote, not be a party to this. If they do become a party to this, they then start arguing, oh, well, we have a direct arbitration agreement. We don't have to.
So, I'm sorry, I should have been sharper in my question. Is the reason it matters connected to the kind of arbitrability question in front of us? Once that question is resolved, does it really matter that much whether or not Rigup stays in the case?
No. And
okay.
Look, I don't think it matters even for the arbitrability question, right? Whether or not Mr. Rogers agreed to arbitrate, whether it be the merits or whether it be arbitrability with Tug Hill, that question gets answered the same way. It doesn't matter who's asking. Doesn't matter if it's Tug Hill asking, doesn't matter if it's Rigup asking, right?
Okay.
And to me, those things don't change based on who's asking the question.
Okay.
If there are no further questions, I'm going to move on. I mean, a party cannot be forced into arbitration.
Can I about the arbitrability issue. So as I understand it, the defendants are sort of with you that a question of contract formation, whether a contract exists, has to be decided by the court. I think they agree to that in their brief. Although I don't mean to put words in your mouth. We can discuss this. But I think their position would be that's not this case. Like there is a contract here. It's conceded that an agreement exists between your client and Rig Up. And so now we're just talking about whether non-signatory Tug Hill can enforce it, and that goes to the scope of the contract. And that's a question for the arbitrator. So what's wrong with that?
So that is kind of where the rubber hits the road.
I think so.
Between the two of us. They say, hey, as long as we can find an agreement where you agree to arbitrate with someone, right, you must arbitrate with us, right? If you sign an arbitration agreement with T-Mobile and T-Mobile has a delegation clause in it, and we show up with that contract, you must arbitrate with us.
Right, at least arbitrability, at least the threshold questions, yeah.
That, to me, is squarely rejected by this court's precedent. Among them, Gibbs versus Hayes Investments and Hengel versus Trepa, which we're going to talk about here in a second, right? Again, a party can't be forced into arbitration. Rather, as this court said, the parties must actually contract to arbitrate disputes between them. The question here is not whether or not Mr. Rogers agreed to arbitrate with someone. Literally everyone in this room has agreed to arbitrate with dozens of companies, credit card companies, banking companies, rent-a-car companies, hotels, you name it, right? Many, if not most of those arbitration agreements incorporate the AAA rules, which is one of the reasons they say that there's this delegation clause, right? That doesn't answer the question of whether or not I've agreed to arbitrate anything with someone else. It is a problem of trying to use scope, as the Fourth Circuit put it. They're trying to answer the question of who must arbitrate by looking at what must be arbitrated. And the fact that I have agreed to arbitrate arbitrability with you, Judge Harris, doesn't tell me anything about whether or not I've agreed to arbitrate arbitrability with Mr. Bolden. Sorry, I was going to call him Barry. My friend Barry over here. So let's take about how the Fourth Circuit has analyzed this. What we're talking about is whether or not the folks at Tug Hill can enforce the delegation clause, because that's what they want to do. They want to force us to arbitrate arbitrability with Tug Hill. And under Fourth Circuit law, we can contest the enforceability of a delegation clause by making the exact same arguments that we did with respect to the arbitration as a whole. Fourth Circuit, Third Circuit, most circuits are different from the Sixth Circuit in that regard. And we have said, look, we didn't agree to arbitrate anything. We didn't agree to arbitrate the merits. We didn't agree to arbitrate arbitrability. And so, as with any other agreement to arbitrate, because we've challenged the delegation clause specifically, and I'm quoting here from Hengel versus Trepa, quote, the court must evaluate the validity of the delegation before ordering compliance with the clause. The contract comes first. First is there an agreement between us and Tug Hill, or is there an agreement that Tug Hill is authorized to enforce? Indeed, in Gibbs versus Hayes Investments, which we talked about a second ago, this means that this court must decide, quote, the enforceability of the delegation provision. Enforceability is the question. Can they force us to arbitrate? The existence and enforceability of any agreement in this case, any case, are determined by reference to state law. My friends in the district court said West Virginia law controls. Let's stick with that for now. West Virginia law is clear that...
I'm sorry, before we stick with West Virginia law, can I ask you, is there any material difference in West Virginia and Texas law that's been kind of identified in the briefs when it comes to these third-party beneficiaries?
So, under West Virginia law, the standard is sole benefit. That's why we cited West Virginia Code 55-8-12, right? So if there is in order to be a third-party beneficiary, you have to show that that particular clause, that particular provision was for your sole benefit. They sort of hew to the old, common law from England view of third-party beneficiaries. Folks over in England take a much stricter view of who can be a third-party beneficiary than most courts do in the United States. The statute that governs in West Virginia has been around about 100 years, maybe even a little more at this point. It's been unchanged for that. And after the district court ruled in this case, the West Virginia Court of Appeals again confirmed in West Virginia, we do sole benefit.
Okay, I'm sorry, so you think West Virginia law applies? You don't, you think Texas law applies, right?
So I do think,
Oh, I'm sorry, what is your position?
right. My position is the district court said West Virginia law, they've said West Virginia law.
Right, but you said Texas law.
I did say Texas law, and they've argued that I've waived that. And the reason I say Texas law is because in fairness to y'all, is not in the record, but paragraph 23 of the agreement that they rely on, which they filed in another court in New Mexico, says this agreement is governed by Texas law, and it calls for venue.
Yeah, how come the copy in our record has that part blocked out? Where did that copy that we have in our record come from?
Came from them, and they say that's all we got. There are a bunch of sections missing, and because I've run into rig up before, as I'm sure everybody here knows, it's kind of a source of consternation for me. Thankfully, this is the older agreement. They've modified their agreement a bunch of times to cover third-party beneficiaries, for example, like the folks at Tug Hill.
But they provided it, it's just so when they copied it, they have that overlay up there, and they've cut out you quoted it in your brief, but it's at the top of the page, and we just got 2/3 of the paragraph. The first third's gone, because it's covered up by that label. I don't know what that is.
They say they do not have, this is not in the record.
Yeah, we can
I'm
ask
just
them.
telling you, like, what they say to us is, we don't have a copy that doesn't have that cut off. That's what they say.
Am I right that in district court, though, but I can ask your colleagues also, but I thought Rig Up conceded in district court? No, there's a choice of law provision with Texas law, or no, did that not happen?
No, they argued for Texas law when they filed their motion. They said
Okay,
Texas law should
okay.
apply. The folks at Tug Hill said and
Right.
continue to say it's West Virginia law.
Okay.
So, West Virginia law, by the way, is clear that when the parties stipulate as to whose claims will be subject to arbitration, courts are obligated to respect that decision because they enforce the plain language of the contract.
Well, let me ask you this, just going back. That part of paragraph 23 that's blocked out by the copying thing, do both parties agree that it provides for Texas law? I mean, somebody quoted it in his brief.
I quoted it in the
Yeah, and do they both sides agree that that's what it says? I mean, we don't have to get a copy sent to us, do we?
I don't know whether they agree or they don't. They continue to argue that West Virginia law applies, and there are reasons, even if there is a choice of law clause, that it could apply.
Well, I know, but I want the record to be clear. I mean, this record has got that blockage. It's on page 49, and it looks like it's just sort of blocked out on every page at the top. That's the way it was copied, but you quoted it, and the other side, I don't think it's disputed. It seems to me that's something that the attorney should be able to agree without having to go and order a good copy sent to us. But I'll pose that to your colleagues. But you agree with what you stated in your brief as to what it says. You quoted it verbatim.
I copied it from what they told the court in New Mexico it said. That's what I got.
Okay.
As noted in West Virginia Department of Health versus Denise, which is 245 West Virginia 241 at 245, excuse me, 241 at 245, which is a 2021 case from West Virginia's highest court. The fact that they've identified who is a party to the agreement and who is not in the arbitration agreement poses a problem for them, because Tug Hill is neither a party to the rig-up agreement nor a party that Mr. Rogers.
Well, more importantly, from that point, on that argument, the arbitration agreement limits it to 2 people, and any dispute between A and B.
Right, and I'm cutting into my rebuttal time, so I'm
Yeah. All right, we'll hear from you on rebuttal. All right, Mr. Bowman.
May it please the court, Barrick Bowman, my co-counsel Christian Ankowiak, and I represent Appellees Rusco Operating, or Rig Up, in Tug Hill. The district court was.
Who do you represent?
I represent Rig Up, Your Honor.
Okay. Now, Rig Up has those conditions, and on page 49, and you agree the quote that they have there is what's underneath that label?
Your Honor, sitting here today, I don't know the answer to that question. What I understand is that agreement in the record is the only copy that our client still maintains from 2016.
It's on several other pages too. They're blocked
Yeah,
off on
every
several,
page, yeah.
multiple pages.
Yes, Your Honor.
So this is not a copy of the agreement.
Your Honor, this is the best copy that
It's not a copy of the agreement if it's not complete.
It is an incomplete copy of the agreement. Yes, Your Honor.
It's an incomplete copy of the agreement.
I'm happy, however, to go pose the question and file a supplement
I
with
mean,
the
they've
court.
quoted it, and he told you where he got it from. He got it from a clean copy where you could read it that was put in another case. And it seems to me that you should know that, as a matter of fact, choice of law was an issue in the case, and you probably should know that.
Respectfully, Your Honor, I can't sit here today and answer that question. Best that I can tell you is, from my understanding.
Well, then I'm going to ask you to, within 5 days, to get us a clean copy of the agreement, and supply it to your opposition and to the court.
Certainly, Your Honor.
Am I right that that Rig Up conceded in district court that Texas law, or conceded, that took the position in district court that Texas law applies?
In the district court, Rig Up filed a proposed pleading in support of its intervention motion because I believe its 24C requires that. That proposed pleading does assert that arbitration is appropriate under Texas law.
Okay, so
It
what?
does not expressly address whether Texas law is appropriate or not. It just asserts Texas law.
Well, that's the whole issue. So you're now disputing it?
Your Honor,
I mean, what basis do you make that allegation?
from what I understand, the agreement, let me back up. I don't know the answer on whether there's a choice of law provision. I believe that
Well,
arbitration is required under
did you
Texas
draft
law.
the pleading below?
No, Your Honor, I did not.
Okay, but Rig Up did say in the district court that Texas law applies. And what is your position now on what law applies?
I think our position is West Virginia law applies under choice of law principles.
But and how do you reconcile that with having told the district court that it was Texas law?
Because I think, as the district court found, the performance of this agreement was in West Virginia.
So you've changed your position on choice of law.
I don't think that there was a firm position, Your Honor, was attached
well,
to the proposed pleading.
Yeah, well, if it says that it's appropriate under Texas law, I think it's fair for the district court to think you think Texas law applies. Did it say anything about West Virginia law?
I don't believe so, Your Honor.
Okay, well, I mean, why don't, let's just assume for a second that you took the position in the district court that Texas law applies. I'm just so perplexed, but I assume that's because you knew what the agreement said, that you knew that it had a choice of law provision, but you're saying that's not right. It was for some other reason that y'all thought Texas law applied?
I think arbitration is appropriate under either Texas law or West Virginia law.
Well, I know, but I'm just trying to figure out what happened here and what the parties' positions are as to which state law applies. So I'm just frustrated that we don't have an answer to that question.
I understand your frustration, Your Honor. Respectfully, I don't think it necessarily matters because I think the result on the third-party beneficiary issue is the same. And also, this court need not get there because the delegation clause resolves all questions. And if
Except you've got, your contract has got so many indicators that suggest that the relationship between Tug Hill and the plaintiff is a matter for them and not for Rig Up. It says, any interaction or dispute between you and company, that's Tug Hill, are solely between you and that company. Rig Up and its licensees have no liability, obligation, or responsibility for any interaction between you and company. And then it says over here at the disclaimer, it says Rig Up is not responsible for any interaction or other third party in relationship to projects completed by you. Party to disputes or negotiate, a Rig Up will not be a party to disputes or negotiations of disputes between you and companies. And despite the fact that you say you will not be a party, you're seeking intervention.
Your Honor, I think that.
And then you go to the arbitration clause and it limits it between just the two.
Yes, Your Honor, and I'll address both of those issues. First, on the intervention point, I think there is no abuse of discretion here. Nothing.
I'm not talking about abuse of discretion. Why you think you could intervene when you have promised not to intervene?
Rule 24 does not implicate contract.
Let's stay away from the rules. Let's go to the facts. I mean, you don't think this is binding on you?
Your Honor, we have clear interest in this lawsuit, interest in our business model, interest in.
You may have a lot of interest, but you agreed will not be a party to disputes, not be a party, and that's what you want to be.
And Your Honor, there's no authority that says that you can contractually waive your right to intervention. There's no.
I don't understand why not. If I say I'm not going to intervene in your case and you give me $100 for that, it's a contract.
And my response is that Rule 24 does not speak with respect to contractual waivers or anything like that. There's no authority that says that you can contractually waive a right to intervene. I do want to address your other point on the arbitration clause. And I understand that Section 24A says that in the interest of resolving disputes between you and RIGA. But I want to focus the court's attention to Section 24H, and that is the delegation provision. That provision says that the arbitrator has the exclusive authority to resolve any dispute.
Is that page 49 you're talking about?
Your Honor, it is page 51, J51.
Yeah, but that's in the arbitration between the two. It says, in the interest of resolving disputes between you and Rig Up, most expedient and cost-effective is arbitration, etc. You and Rig Up are each waiving the right to trial by jury or to participate in a class action. You and Rig Up. It continually says, Rig Up, who will pay the fees and so forth. The arbitration between you and Rig Up will be settled under the Federal Arbitration Act. That's the limit of the arbitration clause. Now you go to arbitrability. The arbitrability is to decide that arbitration. But that arbitration in no way includes or issued for the benefit of some third company that they send an employee to.
Your Honor, I would argue that's for the arbitrator to decide. The arbitrator has.
Hold it. Tug Hill is the party. And Arthur Anderson makes pretty clear, the Supreme Court said you can't start bringing in these other parties. The arbitrability only goes so far. You still have to have the contractual authority for an arbitration clause.
Your Honor.
And between Tug Hill and Rogers, Tug Hill and Rogers, they entered into an arrangement. I don't know if there was any writing, but certainly that the relationship between them, there is no arbitration clause. And the arbitration clause you go to where their broker or their matchmaker, Rig Up, said if there's any dispute between matchmaker and Rogers, that's the way they'll handle it. I mean, there's so many indicators that there's no third-party beneficiary, or is never incorporated, or never intended to be incorporated. They never even decide issues involving Tug Hill and Rogers. And so you want us to bypass all of that and say, nonetheless, let the arbitrator decide.
Because that's exactly what Henry Schein says. Henry Schein says that if an arbitration agreement exists, and as Judge Harris pointed out, this agreement exists. We don't have the typical, I didn't sign that, I didn't check that box. Rogers can.
Well, sure you do. Tug Hill has zero. There is no contract between Tug Hill and Rogers that has an arbitration clause. So now the question is, Rogers used a broker to get that job, and Rogers entered into an arbitration agreement with the broker and said, between us, if there's a dispute, we'll resolve it by arbitration, and the arbitrator will decide the arbitrability of our dispute. But it says clearly that arbitration clause is between just Rogers and Tug Hill, and it also says that any dispute elsewhere, we're not going to be involved in.
Your Honor, if I can respond in 3 parts. First, an agreement does exist. And I understand the argument. There's no agreement between Rogers and Tug Hill. But this agreement in 24H says that the arbitrator decides any dispute with regard to enforceability. And this is exactly what that dispute is. Tug Hill and Rigup say this must be arbitrated. Rogers says no. And in the Supreme Court, and in Henry Schein, I will note, involved a non-signatory seeking to compel arbitration, and the Supreme Court drew no distinction there. The Supreme Court said that if there is a delegation clause, the court goes no further. We cannot draw lines, even if we think, while looking at the scope.
You're overlooking all the court's decisions talking about the contract is for the court, and the determination of the parties and all of that is for the court under state law, contract law, and it's treated like any other contract. And you know, that's you have to start with that. Arthur Anderson, AT&T. I mean, these cases are just clear as a bell on that. Arbitrability. If you have a contract of arbitration, arbitrability is a delegation clause lets the arbitrator determine arbitrability. But you have to first get to arbitration. You have to get the people agreed to it. Tug Hill didn't agree to it. They didn't even know about it as far as we know.
Well, Your Honor, there's a difference between a signatory seeking to compel a non-signatory to arbitrate and a non-signatory. The non-signatory is agreeing to arbitrate. But again, I want to focus you on the language of 24H. Any dispute, it doesn't say any dispute between you and Rigup. It says the arbitrator says any dispute. And even if this panel thinks that, you know what, that doesn't make sense.
So we have a dispute between Comcast and AT&T, and they can come in and enforce that agreement?
And Henry Schein answers that exact question, Your Honor. It says that even if there's a frivolous argument, arbitrators are well equipped to answer it. And if it is frivolous, arbitrators can impose fee sanctions, cost shifting, and the like to deter and prevent such actions in the future. Henry Schein answered it. Once there's a delegation, you go no further. I see that my time has ended, and co-counsel Christian
All right.
Kowiak will continue the argument.
Mr. Ankoviak, is that the name, pronunciation? Yeah.
Thank you, Your Honor, and may it please the court, Christian Ankoviak representing Tug Hill. It's a privilege to be here today with my colleagues and to be able to have this conversation with you. We divided our time so that I could address third-party beneficiary, but I want to pick up very briefly on that last point that my colleague was referring to when he was talking about the wholly groundless exception. And my concern, Your Honor, is that if this panel goes down the path of analyzing the parties, as Mr. Birch has suggested, it will effectively revive the wholly groundless exception.
I did not read Henry Schein as saying that if there is not a contract between the two parties, the court can nevertheless enforce the non-contract by sending it to arbitration. And I think it's not just all the Supreme Court cases that Judge Niemeyer has given you, but we also have a case, the Raymond James case from our court, which I know isn't cited in the briefs, but this was exactly the question in that case where there was an agreement, no question, the party that, I'm going to get this mixed up, but the party there was an agreement, it was signed by one of the parties, and the dispute is whether the party objecting to arbitration has agreed to arbitrate with the particular parties on the other side of the case. And we said in no just unmistakable terms, this is not a question of scope. This is a question of contract formation. Who has decided to arbitrate? That's for a court to decide. And until we know that there's a contract between the parties before the court, here, Tug Hill and Rogers, we have nothing to enforce by sending it to an arbitrator. And I just don't see how we get around that in this case, because this contract, as Judge Niemeyer says, if there was ever a contract that made clear it was only between two parties, this is it.
So, Your Honor, I think the simple question before the court here that we're all arguing over is who decides.
Right, and I'm saying we held in Raymond James that the court decides who decided to arbitrate.
But I think the point you made at the very beginning when you asked the question about whether formation's really an issue, doesn't everybody concede that an agreement exists?
I don't want to get into like some metaphysical space, but I don't even know what it means to say like a contract exists. Usually when a court says a contract exists, we can enforce it, we mean there's a contract between the two parties in front of the court. Is there any other context you can think of where courts enforce contracts without first determining that the parties they are enforcing them against are parties to the contract?
No, Your Honor. I think the way, though, that the law has evolved to the point of Henry Schein is what the Supreme Court was saying is, if I'm a party who resists arbitration, and I've entered into an agreement where I agree to delegate arbitrability to an arbitrator, then that's the end of the inquiry. That's the way that we read.
If we don't do that in any other context, if there's no, and I couldn't think of one, so I don't mean to sort of ask a stumper question, but I tried hard to think of another context where a court might enforce a contract against two parties without first determining that those two parties are bound by the contract. The Supreme Court has been so clear that arbitration agreements are supposed to be treated like any other contract. No worse, but no better. And just conceptually, I'm really struggling with this idea that we could enforce a contract without first, against Mr. Rogers and Tug Hill. We could say, you two have agreed to arbitrate your dispute, including arbitrability, so we're sending this all to the arbitrator without first determining that those two parties had entered into a contract.
I think the issue, Your Honor, is that the Supreme Court recognizes the arbitrator may decide that this is not properly an arbitration.
You know, you repeat that continually, and that goes to the notion when you delegate to the arbitrator the scope of arbitration. But before you even get to the arbitrator at all, you have to have a contract to get to him. And the question is where is the contract to get to the arbitrator? And that's a question for the court under state contract law.
I agree, Your Honor. And our position is that Henry Schein tells us if there is an agreement, that is sufficient. I understand that we may disagree on that point, but that's how we read Henry.
Well, we have to have an agreement, but there is no agreement between Tug Hill and Rogers. Zero.
I don't think the court requires us to go further and ask between the parties if the issue
Excuse me.
as it is here.
Well, if there's no agreement between the parties, then it's absurd to say they're bound by something there's no agreement with them.
If I were analyzing this as a matter of first impression, I might agree with you and write it the same way. But that's not how we read Henry Schein's directive. And we're working with what we believe is the directive from Henry Schein. But in the 2 minutes I have left, I want to simply also argue that we think that there is an alternative independent basis, third-party beneficiary. We think that there's a third-party beneficiary right to stand in the shoes of Rig Up to send this matter.
That contract wasn't entered into for the benefit of Tug Hill. And it says it explicitly. I mean, it basically says what between Rogers and Tug Hill is between them. 2 or 3 times it says that.
We are required, whether it's under West Virginia or Texas law, to look at the contract as a whole. There's numerous places where the only party who could enforce a right under that agreement is Tug Hill, particularly because of all the reasons Your Honor mentioned early on when aspects of the agreement. Under that standard, we think...
Rogers has raised a dispute with Tug Hill, hasn't he?
Correct.
And the dispute he has is only with Tug Hill, not with Rig Up.
That is how he has pled his dispute.
He's seeking compensation for overtime under the FSLA. Now, it's explicit in the contract with Rig Up, he had with Rig Up, that Rig Up and he are not going to involve that contract with Tug Hill. It says, basically, it says, we'll not be involved in any dispute negotiation. We will not be a party to any action. And all of a sudden, you're coming in now saying that's for the benefit of Tug Hill. I don't get it, but.
Well, Your Honor, I think if you look at the agreement, there are numerous instances where there is a direct benefit. For example, and ironically, Rogers agrees to indemnify Tug Hill, the company mentioned generally, for misclassification issues in the agreement. Only Tug Hill would be in a position to enforce that if there was a breach of that type of representation. So we think that that and other provisions that we discussed and were discussed by the district court evidence that we stand in the shoes of Rusco and for that reason can enforce the agreement. I see that I'm out of my time. Okay. Thank you.
Thank you. Mr. Birch?
Thank you, Your Honor. I would like to say that I have never seen a clean copy of the terms. What I saw was their lawyer in a case called Oldham versus Nova Mud typed it out and said, this is what it says. I've never seen a clean copy or a complete copy of these terms. And the folks at Rig Up have told me that they don't have one. My friends are just flat out wrong when they say that there is no authority for the proposition that you can contractually waive the right to arbitration. Rusco, Rig Up, the same people sitting here today lost precisely that issue in the Western District of Texas in a case called Johnson versus Parsley, which is 2021 Westlaw 844-2044, where the judge held that they were attempting to do precisely what they had contractually agreed not to do, which is become a party. We've beaten this to death, but the folks at Tug Hill have no arbitration agreement with Mr. Rogers. The existence of the contract is a condition precedent, if you will, to ordering arbitration. My friends say, no harm, no foul. Order him to arbitration, even if he didn't agree to arbitration. And then if the arbitrator rules in his way, then he'll be all set. But Mr. Rogers didn't agree to let an arbitrator arbitrate arbitrability or anything else with the folks at Tug Hill. Why should he be saddled with the standard of review that is, quote, the narrowest known to man? You know, why should that be the answer? The answer should be, as the court said in Henry Schein, of course the court decides whether or not there is a contract in the first instance. For there to be a delegation clause, there has to be an arrangement, an agreement between the parties that are involved in the dispute. Here, that's Rogers and Tug Hill only. My friends also say that they cite the provision at 24H that talks about the arbitrability or the delegation provision under this agreement. Again, as I think it was Judge Niemeyer pointed out, that presupposes that they're part of this agreement. Section 24 says how Rig Up and the folks at Rig Up and Mr. Rogers are going to resolve their disputes. Recall, the terms of service is a defined term under these contracts. And it says in in section 25, Mr. Rogers, quote, "You acknowledge that these terms are between you and Rig Up only." I don't know how much clearer you can get when you're trying to say these terms govern the disputes between me and you and not with someone else. That's a defined term in the contract. And I want to go back to the West Virginia court, because again, it's, seven courts have addressed this issue under Texas law, or seven different judges have addressed this issue under Texas law as to whether or not Tug Hill can enforce this arbitration agreement. They've all said no, including a panel of the Fifth Circuit. The other cases include, in addition to Heiser versus Enzone, they include Oldham versus Nova Mudge, Chopin versus Parsley Energy, and Johnson versus Parsley Energy. Under West Virginia law, if that's what we're going to say applies, the court, was very clear in the case of West Virginia Department of Health versus Denise, that when you use a defined term, when you say, here are the parties that are subject to this arbitration agreement, we take you at your word. If you say, here is who has agreed to arbitrate, that's who's agreed to arbitrate.
Is that the Supreme Court of Appeals of West Virginia you're talking about?
It is. And
That's in your brief?
that's a fair point. I don't know the answer to that question. But the citation is 245 West Virginia 241. It's a 2021 case.
All right.
Thank you very much.
Thank you, Mr. Birch. We'll come down, greet counsel, and adjourn court for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and the